significant. And some of them were judgments that you wrote quite early in your judicial career.
Yes, actually, that first one, the chairperson and commissioners, Afrox Limited, was the first judgment ever that I wrote. I wrote it as an acting judge. It was the first judgment that I ever wrote.
And before then, you enjoyed the privilege of criticizing the judgments of those who were members of the bench in the course of your representation of your clients.
Yes, well, when you represent clients, you have to deal with certain judgments, and sometimes you have got to make submissions that they were wrongly decided. So it's part of one's job as a lawyer.
Yes, indeed. Have the principles that you propounded in the many judgments that you wrote stood the test of time, as it were, as far as you know?
Well, to a very large extent, I think they have. Talking about that first one, Afrox, that you see there, it was handed down in '97. I was an acting judge of the Labour Court. As I said, it was my first judgment. But a few years later, it was upheld by the Labour Appeal Court. Many of the judgments that I have written have stood the test of time. Well, others, of course, were not taken on appeal, and therefore we don't know whether if they were taken on appeal, they would have been able to withstand the scrutiny of an appellate court. But you have Ndima there at page 7. Well, it's typed page 7, but paginated page 8.
Yes.
That is a case which I also wrote as a judge of the Labour Court, which had a very meaningful impact on the lives of workers in this country, because in dealing with the matter that I dealt with there, I came to recognize that there was a problem in the Insolvency Act, in that when a company got liquidated, when a provisional liquidation order was granted, the law was that the contracts of employment of all workers would automatically come to an end, just like that.
Yeah.
But the problem was that that would be a provisional order of liquidation. And if later on the final order of liquidation was not granted, and the company survived, those workers would no longer be there, and the company would be able to take whoever else they wanted. And I made a recommendation in that judgment that Parliament should consider amending the law to make sure that when a provisional liquidation order is granted, the contracts of employment of workers do not come to an end, do not terminate, but they are provisionally suspended pending the outcome of the liquidation proceedings. And if the company survived, then they would continue. And subsequently, a few years later, an amendment was made in the law, and that recommendation was accepted. And as far as I know, that is still the position now, that when a provisional liquidation order is granted, the contracts of workers do not immediately come to an end as it used to be before this judgment of Ndima, or before the amendment to the legislation that I have read in books was inspired by this judgment. So there is that protection which now exists. And then we also have the next judgment there is Mandisa and others versus Steve Spar, Blackheath. That was also a very important judgment, which I wrote as, I think I was acting judge president of the Labour Appeal Court at the time in either 1999 or 2000. I think it was 1999. And there had been a lot of uncertainty in the law about whether workers who go on illegal strikes are entitled to be heard before they can be dismissed by their employer. There had been different judgments in the old industrial court and in the old Labour Appeal Court, and I think, in the old appellate division. And I took the opportunity to investigate this issue quite extensively. I considered judgments that stretched over, I think, over 10 years in the different courts to see what they had said, as well as academic articles on the subject. And I came to the conclusion that the correct position was that the fact that the workers may have been involved in an illegal strike is not something that disentitled them to the basic right to be heard before they could be dismissed. After I'd handed down that judgment, there was quite some noise in the media from employers, but that judgment has stood the test of time as far as I remember. I may be mistaken, but I think the Supreme Court of Appeal subsequently approved it. That's my recollection. But as I understand it, that remains the law, that workers are entitled to be heard, even if the employer may think that their strike is illegal. I don't know
Acting Chief Justice, I do not expect you to run through all of the judgments.
Yes.
You could wait and see whether any of the members of the commission would have anything to say in regard to those judgments.
Yes.
But I want to take you back to Ndima and others just for a moment.
Yes.
Because there is a critical observation that I want to make.
Yes.
And I would like you to, comment on it, if you will. And the point which I want to make is that sometimes justice and equity on the one hand and the letter of the law on the other may collide instead of being aligned. And on occasions, as you did in Ndima, judges are constrained to call on the legislative arm of the government to consider legislative amendments in order to cure the defect. And the proposition that I want to put to you and hear you on is whether you consider that when courts make those calls, the legislative and the executive arm of the government bear a duty to give those calls serious consideration, given that courts do not make those calls lightly?
Well, Chairperson and Honorable Commissioners, whether or not Parliament, for example, would give a particular recommendation serious consideration, I guess would depend on what view what Parliament took of the recommendation. If the recommendation seems to be weighty, I would imagine that they would give it serious consideration. But if they maybe didn't think it was weighty, maybe they would look at it and make whatever decision. But what is clear, of course, is that Parliament is not obliged to go along with such recommendations or suggestions from the judiciary. It is up to them. If they think that the suggestion is a helpful one that can solve a particular problem, they could go along. If they think there is another solution, they are free to look at another solution. If they think this solution just shows that this judge doesn't know how these things work, they would reject it.
Of course, I accept that, Acting Chief Justice. The proposition I was putting to you is that at least they must consider.
Yes.
They shouldn't just,
Yes.
brush it aside.
Yeah, no. I think it was the seriously part that I was dealing with, but I would imagine that they should consider, and what they make of it is their judgment call.
Yes, indeed,
Yes, yeah.
indeed. No one can quarrel with that proposition. Then I want to take you to...
Well, maybe, Chairperson, if you would allow me, I know you said we are not going to go through all of them, but may I, with your permission, just refer to the Nehau judgment, which is next in the list? Would you permit me to do that?
That would be on what page?
On page 9, typed 9. Typed 9. And
10 paginated.
Yeah, 10
Yes.
paginated.
Yes, I'm there, Acting Chief Justice.
Okay, all right. That case is also important, Nehau versus University of Cape Town. That is a case in which I sat while I was acting, I think I was still acting judge president. I had not been appointed as judge president as yet of the Labour Appeal Court. Oh no, I must have been judge president because it's 2002. That is a matter in which I sat with two very senior judges who were acting judges of appeal in the Labour Appeal Court. I'm sure that some of the commissioners are familiar with the workings of the Labour Appeal Court, but for the benefit of those who might not be familiar, may I just indicate that the Labour Appeal Court panel that hears cases or whatever case will consist of a judge of the Labour Court, and every judge of the Labour Court is required to be a judge of the High Court, including the judge president of the Labour Appeal Court. So sometimes you would get High Court judges who come and act in the Labour Appeal Court. So on this occasion, I was sitting with two very senior High Court judges. Actually, I think one of them was already judge when I was still a student at university. Very senior judges. We had this appeal. It concerned a legal question whether when an employer transfers its business to another one, when there is a sale of business or when there is there is a sale of business, whether the contracts of employment of the workers go over to the next employer, to the transferee, without their being a need for an agreement between the first employer and the employees, and whether the first employer and the transferee employer can agree to say, your workers won't come to me, I will have my own workers. So your workers are your problem. So we were faced with that legal question in the context of Section 197 of the Labor Relations Act, which deals with this situation. And in that case, my two colleagues, senior colleagues, came to the conclusion that that was permissible and that an employer, the two employers could exclude workers from the first employer from going over to the next, to the transferee employer. I took a different view in the matter, notwithstanding the fact that these were very senior judges. As I say, one of them had been a judge while I was at university. I took a very firm view that I did not agree with them. I wrote my judgment and came to the conclusion that in such a case, the workers of the first employer are entitled to be transferred to the transferee employer. So, but my judgment was a minority judgment because they agreed with each other. That matter went on appeal to the Constitutional Court, and the Constitutional Court upheld my judgment as the judgment that was correct. That protection remains today for the workers arising out of that judgment. I thought I wanted to mention that, Chairperson. Thank you very much.
Thank you, Acting Chief Justice. And of course, you played a pivotal role in the groundwork that gave birth to the Labor Relations Act.
Yes, Chairperson, I had the privilege of being invited by the then Minister of Labour, Mr. Tito Mboweni, in 1994, to be part of a ministerial task team that was given the responsibility of drafting the first post-apartheid Labor Relations Act. It was chaired by Professor Halton Chidle. So I made a contribution as part of that task team.
Thank you. Might I take you to page 25, typed and paginated page 26 of your first bundle?
Yes.
Where you deal with the subject of delay in handing down of some judgments by the Labor Appeal Court.
Yes.
That's paragraph 6, and you say, reading from line 3, this was due largely to the fact that for the best part of my term of office, the Labor Appeal Court did not have full-time judges of appeal. There's just one aspect that I want you to clear in my mind, because as I see it, if judges are invited from the High Court to act in the Labor Court, they hear cases, attract reserve judgments, then there's an obligation on those judges to produce judgments.
Yes, obviously there is such an obligation, because once you have heard a matter, you are under an obligation to do everything you can to deliver judgment as soon as possible without undue delay.
And the fact that they were at the Labor Appeal Court as acting judges of appeal is neither here nor there.
Yes, no, it's
The
not.
point of the matter is that they had cases, attracted judgments, and as you put it, were under an obligation to produce those judgments without undue delay.
Yes, no, that is true. But I do want to make it quite clear that overall, the judges which came from the High Court did the best they could. I had my own delays and my own judgments too. They did the best they could. Sometimes there were delays, sometimes there weren't. There were many matters where judgments were handed down within an acceptable time. But of course, the Labour Appeal Court was really in a difficult position at the time, and the Labour Court. Just to give you a background, when I was brought in as acting judge president at the beginning of August 1999, what had happened was that the Labour Appeal Court had almost collapsed, because at the beginning of that year, the judge president of the Labour Appeal Court and Labour Court of the time, Judge President Myberg, resigned, and his deputy was Justice Froneman. Justice Froneman was deputy judge president, and there was also Judge I think Kron, Judge Nicholson. I'm not sure if I'm forgetting one, but there was also Judge Mlambo. Judge Mlambo was appointed acting judge president. Justice Froneman went on long leave, and the understanding was that he was not going to come back to the Labour Appeal Court. He would go back to the High Court. So you had the judge president gone, you had the deputy judge president gone. I think one day after I had started as acting judge president, I received a call from Judge Kron, who told me that, who asked me whether I had received his letter of resignation from the Labour Appeal Court. I had not received it, but in due course, I think I got it. So you had a number of judges who left, and then Judge Mlambo himself was appointed to the Constitutional Court in, I think, June of that year. So the only permanent judge that was remaining, if I recall correctly, was Judge Nicholson. And that meant you could not have a quorum, because a quorum had to be 3 judges. You had to have acting judges. So if he said he would need to have acting judges, the acting judges would be in the majority. But as it turned out, Judge Mogoeng was going to act during the first term that I became acting judge president. And I think that in the first term or 2 of my service as acting judge president, I sat with, Judge Conradi also was around, he did not leave. So I sat with Judge Nicholson and Judge Conradi and Judge Mogoeng. So the court was almost collapsing, and it had to be rebuilt. And that took some time. There were some challenges in the Labour Court as well. But of course, this is a subject that has been placed before this commission in previous years as well. But that is what happened.
Thank you, Acting Chief Justice. And I take you next to Annexure RZ1 to your questionnaire, which amongst other things contains a long list of judgments that you wrote, both in the Labor Court, Labor Appeal Court, and the Constitutional Court.
Maybe I could just make one correction, if I may, Chairperson. Some of the cases that that list contains are not my judgments, but are judgments which resulted from cases in which I appeared as a legal practitioner. The first 48 or 47 cases are reported cases in which I was involved, mostly that I argued or where I conducted trials, or some of them are where I was the instructing attorney, but most of them are cases which I argued, and I think what they represent, Chairperson, if I may say this, I think they represent something important that maybe we judges don't always acknowledge, and maybe the public doesn't appreciate because we don't tell them. Namely, that when we talk about jurisprudence arising from judgments of courts, sometimes we are so full of praise of the judges who wrote those judgments, but we don't appreciate the role played by the lawyers. And very often, lawyers play a very important role, because sometimes I write a judgment and maybe I don't even indicate that this point came from Mr. Mpofu's argument, Mr. Madonsela's argument. I just write and say there are these points, and then people read, they think it's all my brilliance, you know. But as a lawyer, when a client comes to you, you may be the first one who picks the point. And you have to make a judgment call whether this point is good enough. And sometimes you have doubts, and you talk to your colleagues, you say, what do you think? And ultimately you put it in the papers or in your written submissions, and ultimately that's the point on which you win the case. So I think that the role played by lawyers in our jurisprudence does need to be acknowledged, because very often they do the spade work and they come up with points which ultimately judges accept. So when I put them here, I'm not saying that all the points on which those cases won were from me, but I'm saying that those cases do represent part of the contribution that I believe I made even before I became a judge in the development of our law and in our jurisprudence. I say it reflects in part my contribution.
Yes. No, I was quite aware of that, Acting Chief Justice. That's why I said that list contains, amongst other things.
No, thank you.
And I take your point that, you know, sometimes legal representatives can make the task of a judge very easy. And perhaps nowadays we are not as charitable to counsel as used to be the case, where judges would say, counsel for this party in an able argument, contended this and this and that, but that's all by the way. Some of the judgments that you penned, especially in the Concord, I read and cited them in the course of writing my own judgments. And I do not propose to take you through those judgments.
Yes.
Because, but the point I just want to make, that having read them, they all bear the hallmarks of industry, scholarship, intellectual rigor, and clarity of thought.
Thank you, Chairperson.
The only judgment of the judgments that you wrote in the Constitutional Court is the last one, 208. The
Yes.
judgment of the Minister of Justice and Constitutional Development and others versus Prince. Paragraph 9 of the order in that judgment allowed the use or possession of cannabis in private by an adult person, or cultivation of cannabis in a private place. And the observation that I want to make to you is that that judgment liberated a significant section of the South African population from all walks of life.
Well, if I may...
And you might recall that when it was handed down, there was whistling, ululation, shouting, that greeted this judgment as you read out the order in court. And as we adjourned, the precincts of the court was engulfed in gray smoke. By those who were pleased with this judgment and completely oblivious to the fact that the judgment said that you can use cannabis in a private place.
Well, Chairperson, I just want to say there were others who were not so happy about it, who thought that this judgment was allowing something that should not be allowed, and so there were two sides. But yes. I just mentioned, yeah.
Perhaps whilst you are on that, because I had some of the commentary relating to that judgment. People criticizing it. Some of them not having taken the trouble to read the judgment. Do you want to say something about people criticizing judgments of the court without having read them and applied their minds? Because some interpreted that judgment to mean that I can walk out down the road here with a zol of cannabis.
Yeah. Thank you, Chairperson. I would simply say that it's a good policy to read a judgment before you can criticize, so that your criticism is informed criticism. But sometimes people do criticize without reading it, and we accept, we leave it at that.
Thank you, Acting Chief Justice. Whilst heading the Labour Court and the Labour Appeal Court, you were on a crusade to transform those courts in terms of race and gender, which is highly commendable.
Thank you.
I want to take you to a different topic altogether now, which is Section 174(2) of the Constitution.
Yes.
Which reads that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. I'm raising this with you in the context of the fact that presently there is no white justice in the Constitutional Court. Do you perhaps wish to comment on that?
Yes, Chairperson.
In spite of the fact that from, I think, 2012 or thereabouts, there have been 7 vacancies in the Constitutional Court. And the fact that the last person who is white appointed to that court was, that was in 2009.
Thank you, Chairperson and Commissioners. It is true that at the moment there is no white judge appointed to the Constitutional Court. As the members of this commission would know, there are 2 vacancies that have been advertised, in respect of which interviews will be held in April. For a very long time, there were only 2 white colleagues in the Constitutional Court. Well, no, I'm sorry, I think that's not really correct. For a long time, there were 3, I think. It was, they were Justice Johan van der Westhuizen, Justice Froneman, and Justice Cameron. They all left, at different times. And I think Justice Cameron and Justice Froneman followed each other. I think one left in 1 year and the other one left in the following year, if I'm not mistaken. There certainly was, for the past 2 terms, a white acting colleague in the Constitutional Court. And at the current moment, there is one acting judge in the Constitutional Court. So when this body considers the interviews or interviews the candidates for Concord in April, this body will have an opportunity to decide whether it places before the president for his decision some white candidates to enable him to appoint one or both, or fill one or both vacancies with white judges. So, but that is a constitutional imperative that this body is enjoined to consider each time it considers these matters, and I have no doubt that it will consider it and make its judgment call.
You mentioned those three former justices of the Constitutional Court, and over the years, they steadily became endangered species until they were finally extinct.
Well, I don't know whether extinct is the correct word, Chairperson. But you will be aware, Chairperson, and members of this commission will also be aware that it has taken some time to fill the positions in the Constitutional Court that were filled recently, the two positions that were filled recently, and in part that was due to the lockdown that happened in 2020, which resulted in this body not being able to sit and interview candidates. And then, of course, this body interviewed candidates in April and gave the president a list of candidates to choose from, but there was a legal challenge, and that is why they were only filled, those positions were only filled with effect from January. And in the meantime, two further vacancies had arisen, and actually three, that is now if you count the one for Chief Justice. But the two arose also in October, like the Chief Justice's one, and those are the ones for whom there will be interviews, for which there will be interviews in April. So this body will take all of those considerations into account.
Thank you, Acting Chief Justice. Then, shall we go to paragraph 14? Page 51 of your bundle of documents.
Page 14.
No, paragraph 14, page 51.
Oh,
of
okay.
Paginated page 51.
Okay. Yes.
Where you make mention of the fact that you served as a member of the committee that organized the first South African Judges Conference. What happened to those conferences? Because as I recall, a resolution was adopted in one of them that there should be a judges' conference every 5 years, if I recall correctly.
Thank you, Chairperson. You may be right that there was such a resolution, but I have no recollection myself. But there can be no doubt that there must be certain intervals within which judges could have conferences and discuss matters that they need to discuss. There was, a few years ago, a suggestion that there should be another judges' conference, but it did not happen. And the reason why it did not happen, as far as I recall, is that we were told that there were budgetary constraints that made it difficult for us to have a conference. And I think the question arose as to why, if there were budgetary constraints to have a conference, why we could not use what I would call Plan B, namely that we look at issues that judges would have considered and discussed at conference and ask the heads of court, each head of court, to convene meetings in their own courts of judges where they would discuss the same issues, and then the heads of courts would come together and each head of court would then bring the views of the judges from his or her court to the heads of courts meeting, where then those issues would be discussed, and obviously the heads of court would go back to their courts and report back to judges in their courts. So there was a view that we could look at discussing the matters in that way in the light of the budgetary constraints. But if I recall also, at some stage, and I can't remember at what stage, but there was also an issue which I think the Chief Justice raised to say, let us see what the issues are that must be discussed, because we should not just say, hey, it's time to have a conference, let's have a conference. We should first know what are the issues that really warrant a conference and that warrant the kinds of costs that are associated with a conference. I seem to remember that there was some difficulty in the articulation of the issues. My memory might not be very good, but I seem to remember that there was some difficulty in reaching agreement that those issues were issues that really warranted a conference. And it may well be that the issue of budgetary constraints was raised to say, well, if there are issues that warrant a conference and that warrant the type of costs that go with such a conference, there would still be the problem of budget. But if we can't get over the issue of what are the issues that really would warrant a conference at the particular time, there might be a problem. I think that is what happened as far as I can recall. But I do know that there were judges who were very keen on having a conference. Yeah. But I think that is what happened.
Thank you, Acting Chief Justice, but I want to put it to you bluntly, Acting Chief Justice, that one has to accept that after a period of 5 years, there would be something that judges would need to talk about. And we know that there are many challenges confronting the judiciary. Judge President Mlambo alluded to some of them. Judges' remuneration, tools of trade, conditions of service, and all those issues which can be better addressed when you have at least a substantial majority of judges under one roof.
Well, Chairperson, I would not agree that the mere passage of 5 years would automatically justify having a conference. My view would be, particularly when there had been previous conferences, my view would be each 5 years should be decided on its merits. Because let me make one example. If we met 5 years ago and discussed certain issues, and from our side we were clear what should happen, but we have made sufficient progress on those issues over the 5 years, there might not be a warrant for another conference because we have made a lot of progress. Of course, there may be some issues that might have cropped up after that conference, but whether or not they would warrant a conference would depend on a number of things. But you may have a situation where you have not made progress since the last conference. And then in that event, I think you would have to reflect on why you have not made progress. Because in the context of the judiciary, for example, we know that we don't have the resources ourselves. We have to depend on the executive. It may well be that on certain issues, we know that the executive will not move, no matter how many conferences we hold, because of the discussions that have been held. So I would simply say, in certain cases, yes, it would be warranted to have a conference at the end of 5 years, but my view would be that it would depend upon a consideration of what issues had been discussed before, what progress has been made during the 5 years, and what remains to be done.
Thank you, Acting Chief Justice. Perhaps it would be best to leave it at that and deal with it on another day in another forum. Acting Chief Justice, we have now reached a stage where I must afford you half an hour to tell the Commission and the nation at large how you see the role of the Chief Justice in a constitutional democracy, and also share with the members of the Commission your vision of a functional, efficient, accountable, and independent judiciary in our country.
Thank you very much, Chairperson and Commissioners, for affording me this opportunity. I consider it an honor and a privilege to appear before you as a nominee for the position of Chief Justice. I consider it an honor and a privilege that the President decided to include me among the names of people that he nominated for consideration for this position. I do not come here thinking that I am entitled to any position. I am not entitled to any position. The President has the prerogative to appoint who he decides to appoint. It is not my attitude that because I'm Deputy Chief Justice, I'm Acting Chief Justice, I'm automatically entitled to be appointed as Chief Justice. It is not my attitude either that because I'm Acting Chief Justice, I'm Deputy Chief Justice, I am better than the other candidates. I see myself in the same way as the other candidates, for whom I have a lot of respect, each and every one of them. And I have a personal relationship with all of them. They are very good judges. I have a lot of respect for them. I come here, Chairperson and members of the Commission, because the Head of State considered that I should be considered for this position. I make myself available because it seems that he would like to have a choice when he decides who to appoint as a Chief Justice. And I am here to allow you to ask me questions, and I will answer them to the best of my ability. Let me start, Chairperson, if I may, with making this point. If I'm appointed as Chief Justice, I would consider it a very high honor and privilege. But I would not see myself as some super judge. I would see myself, as I do now, as simply a servant to the people of South Africa. I remain grateful that this body in 2017 interviewed me and came to the conclusion that I was suitable for appointment as Deputy Chief Justice of the country. I'm privileged that I was given that opportunity. I have tried to discharge my obligations and my duties as Deputy Chief Justice to the best of my ability. That doesn't mean that I might not have made mistakes. I'm human. I may have made some mistakes, but I certainly have tried my best to discharge those obligations as Deputy Chief Justice, arising out of a determination that was made by this body that I was suitable for such high office, the high office of Deputy Chief Justice. But high as the office is, I've always seen myself simply as a judge, a servant to the people of South Africa. I think that a Chief Justice in a country such as ours should be somebody of integrity, should be somebody who can provide intellectual leadership in the Constitutional Court, in the judiciary. I think it must be somebody who has a demonstrable track record as a judge, and I think that it should be somebody who is able to work with people and who is able to appreciate the contribution of other leaders within the judiciary, such as other heads of court. I believe that that a Chief Justice must make a contribution to the development of jurisprudence of our country. Of course, a Chief Justice would also be like an ambassador of the judiciary in other countries. He attends or she attends meetings of other legal and judicial bodies in Africa and in the world representing South Africa. I believe that a Chief Justice must be somebody who is humble, must be somebody who appreciates that he's not Chief Justice because he is necessarily the most brilliant of the judges, but it must be somebody who appreciates everyone's contribution and tries to work with everybody. And in the context of South Africa, that is very important because the Forum of the Heads of Court is a very important forum. And as you know, it consists of judges, president of the various divisions of the High Court, judges, president of specialist courts, and the president of the Supreme Court of Appeal. They provide collective leadership of the judiciary in South Africa. And the Chief Justice has to make sure that he views and takes their advices and their views very, very seriously. I think that the Chief Justice should also be concerned about what is happening in all the courts in our country. Are they functioning properly? Are they not functioning properly? If they are not functioning properly, what are the problems that need to be solved? If the President were to confer upon me the honor of appointing me as Chief Justice, one of the issues that I would wish to deal with quite early in my term is to try and complete the institutional model for the institutional model for the administration of the courts that has been dealt with in a proposal that was made a number of years ago to the executive. You will all recall that when we talk about the independence of the judiciary, we talk about the personal independence and we talk about the institutional independence. Many years ago, the question arose, what kind of model of institutional independence do we want as the judiciary of South Africa? And in 2010, I think it was, the then Chief Justice Mlambo, appointed a team or committee that conducted research, which was completed in 2011. And in that research, the proposal that was made was for the establishment of the Office of the Chief Justice. And the proposal was that there would be 3 phases that would lead to the institutional independence that we, the judiciary of South Africa, want. Phase 1 was to appoint or establish the Office of the Chief Justice as a national department. Phase 2 was to establish the Office of the Chief Justice as an entity similar to the Office of the Auditor General in our country. And the third phase was to establish a judicial council, which would require legislation. And the judicial council would be supported by an advisory body that would work with it. The judicial council, it was envisaged, would consist of effectively heads of courts. And in regard to these three phases, phase one was achieved. That is the establishment of the Office of the Chief Justice as a national department. And in this regard, I think President Zuma needs to be applauded because he was the one who gave the judiciary in this country that phase one that had not been there before. We then had the Office of the Chief Justice. What remained was to move from phase one to phase two and to phase three. Now, the proposals that were made by the judiciary to the executive was made around 2012, 2013. But the executive has never come back to the judiciary to say where it stands on this proposal. My understanding is that at some stage the executive said they were going to initiate their own research in regard to what model would be appropriate for South Africa, but they have never come back to say, we reject your proposal, or we accept your proposal, or we would like you to make some changes to this proposal. So that's a very important issue because it would lead, if the executive were to agree, it would lead to phase two of that proposal and hopefully ultimately to phase three. And once we reach phase three, that would give us, as the judiciary of South Africa, I think as complete an institutional independence as possible. Now, that is very, very important. And I hope that the current president and the Minister of Justice would be amenable to going back to the proposal that was made by the judiciary and at least come back and say where they stand. So one of my priorities would be to initiate discussions with the executive on this issue so that, if at all possible, it could be taken forward. One of the issues that I would be looking at is the resolution of a lot of problems that exist in various courts. I have been in touch with judges present in the various provinces, as well as some people within the magistracy or those who have been in the magistracy to try and understand the challenges that are faced by many lower courts, the regional courts and the district courts. And I have a lot of documentation that has been given to me where these problems have been articulated, and a lot of the problems relate to the conditions of the buildings, the buildings that are not maintained properly, air conditioners that are not working, sometimes lifts that are not working, recording machines that are not working for months. Throughout a number of provinces, the problem seems to be very much the same. But there are very many regional courts and district courts which have got those problems, and there are, of course, some high courts which have got a lot of those problems. The High Court in Thohoyandou, I understand, is not really in a good condition. The Judge President of the Limpopo Division of the High Court shared with me a letter that he wrote to the Office of the Chief Justice with a view to it being passed on to the Portfolio Committee of the Department of Justice and Correctional Services, because the Portfolio Committee had planned to pay a visit to Limpopo and see for itself what was happening, but apparently they had to change their arrangements. And he was lamenting the fact that they were not able to get there, because he wanted them to see for themselves the conditions of the courts that Limpopo has. I have been told of some magistrates' courts, and I've been told there are many, where there is no parking within the court and magistrates have to park in the streets. And so the example was made to me of a magistrate who comes out of court after sitting in a case involving an accused, and they go and to the street where they are parked, and the magistrate has to compete for a parking space with an accused. So I've been told that those are problems that have been raised before a lot, but they have not received attention. So there are many of those problems. I'm aware of them, and if I was appointed as Chief Justice, together with the Judges President, I would want to see why those problems take long to resolve. I've been told that in some cases the problem is with the Department of Public Works, but some of the things would not fall under the Department of Public Works. Those things would need to be looked at, because they also affect access to justice, particularly when you start talking about recording machines that are not working and cases can't continue because the machines are not working. But I want also to say, Chairperson and honorable members of the Commission, if I'm appointed as Chief Justice, I would not be wanting to start everything all over. Firstly, because I have been part of the leadership of the judiciary. There are measures that have been put in place which I know enjoy the support of the heads of courts and enjoy my support. The former Chief Justice, Justice Mogoeng, introduced structures that are aimed at enhancing the efficient operations of the courts. The heads of court raised these ideas, and the result was that we have in every province committees that are called PEECs, Provincial Efficiency Enhancement Committees, whose main task is to identify anything that impacts negatively on the efficient working of the courts and address them. The stakeholders who form part of the PEECs will be the judiciary, will be SAPS, will be correctional services, will be NPA, and so on. So that because all of these stakeholders have something to do with justice, the administration of justice, they will come together and see where the problems are that might impact negatively on the operation of the courts, whether we're talking about the lower courts or the high courts. I am told by the judges president of the various divisions that these PEECs are working very well, generally speaking. There may be some challenges here and there, but overall, they say they are working very well. And therefore, I would retain those structures. I would want to make a contribution for them to work even better. But those structures I would retain. And I was just concerned when I learned that the Department of Public Works, certainly in the Free State, doesn't come to those meetings. Maybe they came once or twice, from what I've been told, but they don't seem to be taking the PEEC in the Free State seriously. But it may be that in other provinces they are taking part. But a lot of the problems would require the Department of Public Works, and therefore it is important that the Public Works should take part. So I would also refer to the NEEC, that is the National Efficiency Enhancement Committee. It is also a structure that was introduced by the former Chief Justice. It meets at national level, and it looks at any issues that are escalated to it by the PEECs. But the real bodies that are close to the ground, close to the courts, are the PEECs. The NEEC has not met in a long time, I'm told partly because of lockdown, but I understand that part of the delay might have been that the PEECs had not escalated any serious issues. But I know that the National Director of Public Prosecutions has asked me to convene the NEC and NEC meeting, which I think will be convened in due course. So I would go along with those structures because they are working. But let me talk about, if I may, Chairperson and Commissioners, about the Constitutional Court, because the Chief Justice is the head of the Judiciary and the head of the Constitutional Court. Excuse me. There have been problems which have been articulated publicly about delays in the handing down of judgments in the Constitutional Court and delays in disposing of new applications in the Constitutional Court. When I chaired this body in October, when we interviewed candidates, that issue was raised sharply with candidates, and members will recall that at the end of that session, I did say that I thought it was legitimate for people to raise those concerns, and I said that I would be looking into the matter so that we can deal with the issues. There have been delays. I think that one reason, the main reason, I think, for delays must be the expansion of the jurisdiction of the Concord. As you will recall, in 2013, the Constitution 17th Amendment expanded the jurisdiction of the Constitutional Court. And I think that that has played a very important role in that regard. It may well be that another reason is that when one looks at our judgments in the Constitutional Court with regard to our jurisdiction, maybe they send different messages to the public as to what issues or what kinds of cases we have jurisdiction to entertain and what types of cases we don't take in. That has been a problem for quite some time. At some stages we think we have solved it, and then, but it continues. There have also been delays in disposing of new applications, and new applications are basically that when you want your case in the consular to be decided to be heard by the consular court, you have to apply. You apply for leave to appeal, or you apply for direct access, and those are the applications I'm talking about. We discussed as colleagues these issues. And in regard to new applications, we agreed upon a new way of dealing with new applications. In the past, the arrangement would be that 2 colleagues would be on duty every week, a week. So two colleagues would be on duty per week, and then the following week is another set of 2. And they would deal with all new applications that came in during that week. So sometimes you would find that there are too many new applications that came during your week. And sometimes there are too few that came during somebody else's week. So the result would be that sometimes some colleagues would be overburdened with new applications where they must prepare memos, and others might not be so overburdened. What we have agreed upon is a system in terms of which new applications would effectively rotate. So as each application comes in, it goes to one judge, and he or she must deal with it. The next application will go to the next judge. It won't go to the same judge, even if those applications came the same day or same week, so that at any one time, one judge doesn't have too many applications to deal with, and they can deal with them in a day or 2, or if there is a delay because they must wait for a response from the respondent, that is that. But that's the system that we have come up with. At this stage, it might be early days, but it seems that it's going to make a difference. With regard to reserved judgments, and what I'm going to say about reserved judgments also affect some applications. You know, the Constitutional Court does not operate like the High Court. It does not operate like the Supreme Court of Appeal. In this sense, let me talk about the High Court. The High Court, very often a judge is sitting alone in a matter. He or she can decide, having had argument this morning, I'm going to give judgment this afternoon, I'm ready. He or she doesn't have to discuss it with any judge. He or she doesn't need anybody's agreement. and it can be an extempore judgment. As counsel completes argument, he or she can say, I'm ready to give an extempore judgment. But, and then of course, sometimes the High Court would be dealing with full bench appeals, so there would be 2 or 3 judges. Supreme Court of Appeal deals with appeals on the basis of sometimes 3 judges, sometimes 5 judges. But this Constitutional Court deals with matters en banc. If there are 11 judges, they all have to take part in decision-making in each and every matter. And there will be different views. One will see a matter in a certain way, another one will see it another way. There will be different motivations to try and reach agreement, because 2 things are expected of the Constitutional Court. One is that it should not delay, just like any other court, it should not delay unduly in giving its judgments. 2, nevertheless, being the highest court and the final court, it must give guidance to the rest of the courts on important legal issues. So you have to try and strike a balance. You can't say, if I see this matter in a certain way and my colleague sees it differently, I don't care, they must go and I'll write my own judgment, because you are going to end up with 5 judgments, with 7 judgments in one matter, and that is also undesirable. People will complain. So you have to talk to one another to try and see if you can reach agreement. And sometimes those discussions take long. The important thing is to strike a balance between not taking too long trying to reach agreement, but at the same time not being dismissive of other colleagues' views just because you are in a rush that the judgment must be out. So it's the striking of that balance that I think sometimes we don't achieve. But with regard to the reserved judgments, I have asked colleagues to consider, and we have not discussed, we will discuss in due course, with regard to judgments that get reserved for too long, to consider whether we should not work on the basis that because the quorum is 8 judges in a matter, whether we should not consider an arrangement in terms of which colleagues who might be having certain judgments that have gone beyond a certain time should not volunteer or ask the head of court if they could be given time to try and finish those judgments without sitting in more matters. Because if, while they are having these reserved judgments, they sit in more matters, some of those matters are matters where they are supposed to write judgment. So you have more judgments piling up, being reserved. Of course, you will all know that there is the idea that the Constitutional Court judges of the Constitutional Court should sit in all matters all together, unless somebody is not available. But we may have to consider that, whether we shouldn't do that in order to deal with the backlog and to avoid having more backlogs. But in the long run, it may be that we should consider, and all concerned should consider, whether the Constitution should not be amended to allow the judges of the Constitutional Court to have fewer panels in regard to certain matters. So we would say, in regard to certain matters, 3 judges can deal with that matter and dispose of it. we don't need to have all 11 dealing with that matter. If we do that, a lot of matters could be disposed of much more quicker, in the same way as in the Supreme Court of Appeal. Because in the Supreme Court of Appeal, you have applications that can be disposed of by 2 judges without other judges being involved. And you have a reconsideration provision where the President of the Supreme Court of Appeal can deal with those applications all by herself. So that may have to be considered to say, let's look at doing that. I think there are jurisdictions that do that. So those are things that we may have to do to try and resolve some of these matters. Of course, the issue of transformation is still important. Although we have made great strides in terms of race, we still need to make a lot of strides in regard to gender or the representation of women in the judiciary. So I would continue to be to work hard to do that. In this regard, I am grateful for what my sister, Justice Maya, said about me when she was interviewed about transformation. I do say in one of the documents before you that when my term of office as Judge President of the Labour Appeal Court was going to be coming to an end, I did identify a colleague who was a woman that I thought should be considered for the position of Judge President. I actually recommended that she be appointed as acting Deputy Judge President, and she was. That was Justice Gampepe. In the Labour Appeal Court, she was appointed acting Deputy Judge President at my instance. And we had discussions that she should consider making herself available. But what changed plans was that she was nominated for Constitutional Court, and she was appointed, and that is how that plan failed at that time. So I would still, want to make my contribution in that regard. But I also want to make my contribution in terms of transformation. In terms of black judges and women judges getting involved in branches of law that for a long time were the exclusive reserve of either male judges and male lawyers or white male judges and white male lawyers. As you may have seen, Chairperson and members of the Commission, one of my master's degrees is in patent law, and part of the reason why I did it was that I hoped to inspire younger lawyers to study those branches of law that have seemed to be the reserve of only certain races, because patent law is one of those branches of law that is dominated by white males. I didn't get a chance to practice patent law, but I did do a master's degree in it, and I hope that that would inspire younger lawyers to consider those branches of law. Lastly, Chairperson, one of the things that I would like the heads of court to consider and the profession with regard to how we deal with matters in our courts is to reconsider the need to initiate proceedings by actions. All those who are lawyers and who practice, they will know that if you are dealing with applications tend to be dealt with quite expeditiously. But if you are talking about trials, they take a long time. I know that as lawyers, sometimes you might like trials because they give you a chance not to disclose everything and not to disclose your full evidence. But it may be that the time has come for us to say, in order to ensure that there is expedition in the disposal of cases, we must take the attitude that if you want to initiate proceedings, collect all your evidence, do all your investigation, put it on affidavit, let it be known what your case really is, let the other side know, and let them do the same, and let the court decide whether it's necessary to have some or limited oral evidence or not. I remember in the High Court and in the Labour Court that when one was doing motion matters, there would be matters where you could hear argument today and give judgment today. There would be matters where you just need to sleep over the matter overnight. The following day you can give judgment. Of course, it happens sometimes with trials, but I think there's no doubt that trials take longer, and maybe this could assist. Chairperson, I thank you for this opportunity, and members of the Commission.
Thank you very much, Acting Chief Justice. At this juncture, I shall take a pause and allow members of the Commission to put such questions to you, Acting Chief Justice, as they might have. What I am going to do now, I'll request the members of the Commission, in keeping with the traditions of the Commission, to indicate to me if they wish to speak. I'll record their names in the order in which indication is given, and once that process has been finalized, we will take the mid-morning adjournment for 30 minutes. Thank you. Thank you. I've noted you, Commissioner Breitenbach.
Thank you, Acting President.
Got you, Commissioner Tsepe. You have been noted, Commissioner Barnett.
Thank you.
I've noted you, Commissioner Shabandawa. Very well, then I have about 20 names. So there you have it, Acting Chief Justice.
It's intimidating, Chairperson. I think it's better to sit where you are sitting. So October was better for me, not this time. You see, I can see Commissioner Mpofu is ready for me.
Unfortunately, I'm not keen on swapping positions. I would rather remain where I'm seated, Acting Chief Justice. Thank you. I make it is 2 minutes to 11. Shall we take the mid-morning adjournment at this stage and then resume at 11:30? Thank you.
Thank you.
Welcome back, Acting Chief Justice.
Thank you, Chairperson.
Honorable Minister Lamula.
Thank you very much, Acting President, and good morning, Acting Chief Justice.
Good morning, Minister.
Thank you. Firstly, is to thank you for the role you have played in accepting the responsibility of the chairperson of what is commonly known as the Zondo Commission. I don't want to go to the lot of details.
Thank you.
You will have seen that South Africans appreciate the role that you have played with the memes that are going around. Some of them have given you very nice names.
Well, I don't see some of them because I tend to stay away from, because sometimes I'm told they can say all kinds of nasty things about people.
Yeah, I know, they also say those nasty things.
No, thank you.
Thank you. Acting Chief Justice, my question firstly relates to the issues you have presented on the model that you have engaged with the executive on. Firstly is that I can confirm that it's true that the executive has to still respond to the issues. There have been engagements, but they have not yet been concluded on the matter. And the matter is now in the processes of cabinet for consultation within the executive to formally respond to the issues that you have raised. And as you are aware, during the consultation, the view of the executive was that it should be a holistic approach. And I think as you get the response, you will be able to engage with the matters. And there will be. My question relates to the current model as it stands, the phase one. On the section 54.1, I'm not sure if the Deputy Chief Justice is aware of it, but it relates to the fact that the minister must consider and address the request for funds needed for the administration and functioning of the superior courts as determined by the Chief Justice after consultation with the other heads of courts in the manner prescribed for the budgetary processes of the departments of the state. What will be your view of this section? Is this enough for now while these engagements are ongoing?
Well, I think, Minister, well, firstly, thank you for informing me that there is some movement that has started to happen from the side of the executive about our proposal. Of course, we would have liked that it didn't take more than 7 years. But I understand like a lot of things in government, things take long. But hopefully once you are ready, we can speed up the whole process so that we don't wait another 7 years. Certainly, Minister, the current arrangement in regard to that issue is better than what was there before, you know. So it's better, but we would have preferred that by now we would have gone beyond that, you know. We would have gone to phase 3, as I indicated, so that it's a matter that's really within the judiciary. But it is an improvement. It is an improvement.
On the second one, what is your view on the operationalization of Section 29 of the Superior Courts Act? I'm not sure if I should rephrase it just to remind you what it is about.
Yes, because I don't have the act in front of me.
Oh, okay. It is the one that deals with the rules of the Constitutional Court, the making of the rules of the Constitutional Court. The Chief Justice, after consultation with the Minister, makes rules relating to the manner in which the Constitutional Court may be engaged in a manner including the matters referred to in Section 172 of the Constitution, all matters relating to the proceedings and before the court. It's about that. And I think you will remember that there have been issues raised from the heads of courts and the former CJ why it should not be operationalized and so forth.
Yes, yes. No, certainly the position is that the rules of courts should actually be dealt with by the judiciary. And there is, in my view, no reason why the executive should really be involved. But we know our history in terms of rulemaking in South Africa. But certainly the rules of courts, all courts, should be made by the judiciary.
Yeah, maybe on that regard, Acting Chief Justice, as you are aware that most of the rules have to go through Parliament and so forth, and there is a role for the public to play.
Yeah.
So, and Parliament has the mechanisms of involving the public. If it's only the judiciary, how are we going to also ensure that the public plays a role in the rule participation, in the rule-making process, and also the mandate of the executive, which is to ensure that there is access to justice, which is not really interference to the court, but we do have a mandate with regards to access to justice.
Well, I don't see why, if as a principle, it is accepted that the judiciary is the proper arm of government to make rules about its own operations, which is the courts, why there should be any impediment in the judiciary being able to invite the public to comment on, for example, rules that it wishes to make. You will remember that if I recall correctly, when for a number of years, the rules of the Constitutional Court were simply the power to make them lay with the president of the Constitutional Court. If you look at the commission, for example, you referred to the commission. When the commission started, I had to make rules. They didn't need to go to Parliament. I consulted those that I needed to consult, and we made rules. They got published. So if we wanted, well, we didn't invite comments, but if we wanted comments, they could have been published, and we wait for comments from the public and then make final rules after that. So I see no reason why, for purposes of receiving comments from the public, they would necessarily need to go via Parliament.
Yeah, the other arm of ensuring access to justice, which it's vested with the executive on the process of rulemaking. How will that be managed through when it's only the judiciary dealings with the rules-making process?
Well, I would not. It's a question of what they do. I would not say they don't need to make an input, but if they make an input when everyone is allowed to make an input, or they get consulted as a stakeholder, they could get consulted. I don't think that there would be a problem. Then the judiciary would make the rules after being fully informed of whatever concerns may come from the executive or Parliament, because they could say, for example, no, these rules impede access to justice, so we suggest that they should be dealt with differently, which is what happens and has happened before when even legislation that affects the judiciary gets made, because obviously legislation will be made in Parliament. Only Parliament can make legislation. Even when it affects the judiciary makes representations to say, in our view, this is what this legislation should say, this is what it should not say. And obviously, the minister responsible for that legislation or Parliament, they might take a view that is different from the judiciary. So it happens in relation to legislation that even though we are the ones who are affected by the legislation, but we make representations, and sometimes Parliament and the executive agree with us, sometimes they don't agree with us, and when they don't agree with us, we accept that they don't agree and it doesn't happen. So I think a lot depends on all the arms of government trying to cooperate and work together to achieve these common goals of access to justice.
Yeah, on the issue of digitization and modernization, Acting Chief Justice, you are aware you have launched it, the former Chief Justice, you have piloted the program in Gauteng through Caseline, and you are now moving to. What has been your role with modernization, and what is your view if you are appointed as a Chief Justice to carry this vision forward? I can state that I have seen the good work you have done in the Commission. You are leaving us now with the legacy of a data center, which I think it will go a long way to help the country in the fight against corruption, but also to digitalize and modernize the entire criminal justice system.
Thank you very much, Minister. I might not myself be very good with IT, but I embrace it wholeheartedly. It's very important. It's the way to go, and that's why in the Commission we have the system that you are talking about. So I'm aware of what has happened, and I'm aware of the pilot project. If I am appointed, I mean the judiciary, it's a heads of court project. If I am appointed, I will continue with the arrangement that the former Chief Justice had and the heads of court had, namely they have a committee that has been specifically dealing with that reports back to the heads of court and reports back to the Chief Justice. I would give that committee whatever support they have. I would not want to change things because it has done a good job. It is led by Judge President Mlambo. It has done a good job, and I would want it to continue.
In terms of rolling out throughout the country, including magistracy and so forth, that is what I wanted also to get going forward, if you are appointed.
Yes, no, I would like that to happen, and short of challenges of budget and so on, if there are no challenges, I would want that to happen as soon as possible.
Yeah, lastly, it's now as an acting Chief Justice, and also in case you are appointed, you will also chair what is called a small JSC.
Yeah.
I could hear from acting President Petzer that you have known each other for many years. It looks like as colleagues and as judges, you are a family that knows each other. How are you going to deal with matters when a colleague that you know very well, you have been together at school, university, and maybe in practice? How do you deal with such issues and you ensure that you lead from the front? You are not always recusing yourself from those proceedings. I do understand that there could be times where you might have to, but how will you deal with these difficult issues of helping to discipline or dealing with issues of misconduct of your colleagues that you know very well?
Thank you, Minister. That's a very important question. Well, the starting point, Minister, is this. The handling of complaints against judges by the judiciary is a very important principle. In other words, that we judges are the ones who must discipline our own colleagues is a very important principle. I certainly would not like a situation where we get disciplined by other people. Of course, I accept, as I have to, Minister, that when all processes relating to the discipline of judges have been exhausted, if we are dealing with a case of impeachment, it ultimately happens in Parliament. But the prior process happens within, firstly, the judiciary. So for that principle to be maintained, judges have to accept that to a very large extent, they are called upon to adjudicate matters of discipline involving people that they know. Of course, there will be cases where you are too close to somebody, but otherwise you are dealing with matters of people that we know. After all, the community of judges is not a big community. So one, that would be my stance. But I must also say, Minister, I would not be new to that. Because after I had been appointed as Deputy Chief Justice, the former Chief Justice told me that as Chief Justice, he would not chair the Judicial Conduct Committee because he chairs the JSC. He said he didn't want a situation where he would not be able to chair the JSC because he chaired the JCC when it dealt with a certain disciplinary matter relating to a particular judge. So it is better that the DCJ should, for all intents and purposes, be the chair of the JCC, but he basically becomes acting chair because in terms of the Act, the Chief Justice is the chairperson. So I have been involved there. Maybe I can take this opportunity to say this, Minister. When I came to the position of DCJ, there was a huge backlog in matters relating to complaints against judges. And I looked into why there was this backlog, and I looked into how the system worked. But to cut a long story short, I ended up sitting down and trying to understand the Act properly and preparing a document that would guide judges, heads of court. Because one, I realized that the Act had a role for heads of court to be involved in these matters, but up to that point, they were not so involved. And I said, well, first of all, those matters that we can give to heads of court to deal with, we should give to them so that we can deal with the backlog. And I spoke to the heads of court and they embraced the idea. I gave them the document that would guide them how to handle this. And since then, the backlog has been sorted out. Well, I haven't spoken to the Secretariat recently, but the last time I knew, the backlog was sorted out, and the heads of court are playing a very important role. But to go back to your question, I have sat in a matter in the Judicial Conduct Committee. It was an appeal with two other colleagues involving one of the heads of court. And of course, heads of courts, we meet, we know each other, all of us, where we came to the conclusion that he was guilty of certain unacceptable conduct, and we decided that the appropriate sanction would be a reprimand, and we asked him to present himself to the JCC for purposes of us administering the reprimand to him. He accepted the outcome of the JCC. He came. Of course, he might not have been happy with some aspects or whatever, but he accepted the outcome. He came to us, availed himself. It fell upon me as the most senior of the panel to administer the reprimand to him, and he accepted. So I think that judges have embraced this system, and they accept that we have to make these decisions against people that we know. So I think it will still work, Minister.
Thank you, Acting President.
Thank you, Honorable Minister. JP Tlaletsi.
Thank you, Acting President, and good day, Acting Chief Justice.
Good morning, Judge President Tlaletsi.
Thank you. I take it the reprimand was not 6 strokes with a light chain. Okay.
No. The reprimand was verbal.
Oh, I see. Incidentally, one of those, as early as 2004, you called to the Labour Court and took me through the ranks, and until today, the rest is history. But then, from what you've discussed with the minister just now, it's my turn to grill you, nevertheless.
I accept, Judge President Tlaletsi, that today I'm subject to being grilled by everybody here.
Wonderful, wonderful.
And I think there are some who are just saying, when am I getting the chance?
Thank you. I won't be long, Acting Chief Justice. Just 2 issues that I want to raise with you. I'll put them, the 2 of them to you, and then I will give you the opportunity to respond. Well, the first one, which is linked to the second one, I think a chunk of your time was taken by the Commission in the past few years. And if you would explain how did you manage to juggle between the Commission and the Court and your functions as the Deputy Chief Justice. And the second one, which I said is linked to the first one, is structurally, the Deputy Chief Justice is not necessarily a member of the heads of court, comes on invitation or as an alternate to the Chief Justice. In your view, would you not consider, if you are appointed, to have the Deputy Chief Justice to be part of that structure in whatever role, so that because you'll be the Deputy Chief Justice is for the whole country and not for that particular court, and we might cause the Deputy Chief Justice to limp if he's not part of the day-to-day functioning and meetings of the heads of court. And then the second issue,
Yes.
yeah, I would want you to share your views on the language policy. We know that you have the official language policy of the courts, and if you've got any views, if you are the Chief Justice, whether we need to revisit that, what needs to be done, we need to improve it. Thank you.
Thank you, Judge President Tlaletsi. Let me start with the question relating to whether the DCJ should not be part of the heads of court. Now, You may be right that the DCJ comes to the heads of court by the invitation of the Chief Justice or in the place of the Chief Justice when the Chief Justice is not available to attend. But for some reason, I was not thinking about it in that way. In my mind, it was as if it has become established practice, but I may be wrong. It arises from my knowledge of how it came about. As you know, I was part of the heads of court for close to 11 years when I was heading the Labour Appeal Court and Labour Court. So some of the things I have that institutional memory of how they came about. For example, Justice Charles Carlson originally didn't come to the heads of court meeting with Justice Langa, who was his deputy. At that stage, the president and deputy president of the Constitutional Court, I think the position of Chief Justice had not moved from the SCA to the Constitutional Court. And when Justice Charles Carlson's term was about to end, he spoke to us as heads of court and asked whether it would not be a good idea for him to start bringing in Justice Langa to the heads of courts and not wait until his term had ended, so that he could get to be involved. He could get to know how heads of court operate, and we agreed. That's how Justice Langa then came in. But when Chief Justice Langa became Chief Justice, I think the then Deputy Chief Justice, Justice Mbuyiseli, may or may not have come a lot of times to the meeting, so you may be right in how you put it. But I do know that at some stage the Chief Justice Langa had asked the heads of courts about bringing him, and the heads of court had said it's fine. But I don't know what happened. And when it was Chief Justice Mlambo, I don't remember that Deputy Chief Justice Mbuyiseli was brought in. So I think probably you are right. My recollection was wrong. I don't think that there is a practice. Probably it's just an invitation. But my view would still certainly be that the Deputy Chief Justice should be part of the heads of court. So if I'm appointed as Chief Justice, I would invite the Deputy Chief Justice to be part of the heads of court. And if there's anything to be done to make sure that it's not by invitation, maybe I would consider. But obviously it is a matter that would need to be placed before the heads of court for them to give their views. That was the one question. The second question, or the first question, related to the fact that I, for some time, was in the commission, but being Deputy Chief Justice at the same time, and how did I handle that? After I'd been appointed as the chairperson of the commission in January, February 2018, while we were putting the infrastructure of the commission in place, and while I was assembling the investigation team and the legal team and looking for premises from which the commission would operate, I was able to sit in matters in the court until I think about a month or two before the commencement of hearings, which commenced in August. Once we were 2 months or 1 month before, I then stopped sitting in matters by arrangement with the Chief Justice, obviously. So I did not sit in matters since the hearing started until the public hearings had been completed, and I went back. But what happened was that the Chief Justice involved me in other leadership matters and not sitting in court. You will be aware that I would call colleagues from other courts that we were inviting to come and act in the Constitutional Court. So he allowed me largely to play that role, but he consulted me a lot on leadership matters and other matters during that time. That is what happened. With regard to the language policy of the court, you probably remember that I chaired a committee many years ago when I was Judge President of the Labour Appeal Court. I think it was under the leadership of Chief Justice Langa, if I'm not mistaken, I'm not sure. When I chaired a committee of the heads of court that consisted of myself, Judge President Hlophe, and Judge President Homo. We had been asked by the heads of court to look into the issue of the language of record, and we had a split. There was the minority view that said it must be English all the way, and there was another view that was Judge President Hlophe and I took a different view and wanted to have more bigger role for all African languages, indigenous languages, while still having English. But the matter was discussed by the heads of courts, and no agreement could be reached. I think we couldn't reach agreement. But what happened was that after Chief Justice Mogoeng came in, he then sought to make sure there was finality on that issue, which had been pending for a long time. And it was then agreed that English would be the language. And I've accepted that decision. I have no intention, if I get appointed as Chief Justice, to try and want to change it. I think it's a decision that must continue.
Thank you, Acting Chief Justice. Thank you, President.
Thank you, JP Tlaletsi. Commissioner Singh.
Thank you very much, Acting President, and good afternoon, Acting Chief Justice Zondo.
Good afternoon, Commissioner Singh.
Good to see you again.
Thank you.
I just want to start off with what is contained in your questionnaire. When you responded to the question on residential address, and you said not provided for security reasons. Now, we all know that of late that the judiciary has been under attack. Members of the judiciary have been under attack physically as well. I recall very unfortunately that a senior prosecutor was assassinated in Umlazi in December. Whistleblowers have been assassinated. Have you had, or are you aware of any threats to members of the judiciary at all levels? And what kind of intervention do you think is necessary if you are appointed as a Chief Justice to protect the safety of judicial officers and whistleblowers?
Yes, the issue of security for judges and judicial officers has been quite a critical issue. Well, myself, my family and I all kinds of threats have been made against me and against my family, arising basically from my work in the commission. But the state has provided protection. During the July unrest and for some time after that, there were threats against judges in general, and various concerns came from judges, and the matter was discussed. I convened a heads of court meeting, a virtual heads of court meeting. We discussed the matter, and the security, the SAPS and other security agencies were quite concerned. Arrangements were made for some protection to be given to justices of the Constitutional Court and justices of the Supreme Court of Appeal, as well as judges president, if I recall correctly. But there were some judges who said, and then it was arranged that if any particular judge faces a specific threat, they needed to communicate with their judge president or head of court, and then arrangements could be made. But there were some judges who preferred not to have that kind of security for certain reasons. But yes, there have been serious threats, and protection is necessary to be given.
Do you think the state is doing enough in terms of providing that protection, not only to judicial officers, but to people like whistleblowers?
Well, I don't have enough facts in terms of whistleblowers, but from what one reads in the media, one is very concerned about whether protection is given. And I believe very strongly that if we are going to have any chance of making a dent on corruption in this country, we must make sure that we protect whistleblowers, because those are the people, together with investigative journalists, who really give us information. The work of this commission, of the commission that I chair, would have been much more difficult had it not been for the investigative journalists that we have in this country and the whistleblowers. I'm indebted to them. I think all of us as a country should be indebted to them, and as a country we should do whatever we can to provide protection to them.
Thank you for that. Acting Chief Justice, there are many elephants in this room, including the one elephant from the IFP that's asking you questions. But I'll just touch on a few of them, because I can't touch on all of them. One is the concern and the objection with regard to Section 176(1) of the Constitution, the term of office and the time you have left in office. And I think you know what the concern is. If you are appointed as Chief Justice, would you be able to fulfill your aims and ambitions and introduce innovation into the entire judiciary within the short space of time? Because earlier on you said you would try and do this and try and do that. But I'm also saying it in the background that you've had the experience so far as Acting Chief Justice. And one would imagine that you'll hit the ground running if you are appointed as the Chief Justice. Would you like to comment on this objection before I touch on any other objection?
Yes, no, thank you very much. I appreciate the opportunity to deal with this. If I'm appointed, I will have about 2.5 years to work as Chief Justice. Chief Justice Mlambo had less than that. He had less than 2 years. But within that short space of time, he made a very big contribution one of which is getting the executive, President Zuma, to agree to establish the Office of the Chief Justice as a national department. That was a very important step towards complete institutional independence for the judiciary. There are other measures. But also, I just need to say, a colleague sent me some information some time back. Unfortunately, I don't have it here. He had a look at how long chief justices in this country stayed in office. I think he went up to the 1800s, and he did that research. And when one looks at that research, one finds that it was not unusual to have chief justices who served for 2 years or 3 years, less than 5 years. I looked at the list there were many. Number two, he said, or that research revealed that the immediate past Chief Justice who served as Chief Justice for 10 years was the second person, Chief Justice, to serve that long, during that long period that he researched. So there is that. So from my point of view, I think there are a number of things that I can do, and one of them is really to see whether I can't achieve an agreement with the executive about phase 2 and phase 3 that we talked about. And if I could achieve that, I would be very happy when I leave office as Chief Justice, because I would know that I have been able to leave behind a judiciary that has achieved that complete institutional independence, which is very critical. But also, a number of things that I think need to be dealt with are things that don't need many years to achieve. I talked earlier on about how courts are struggling to have things dealt with that they should have dealt with easily. Certain courts, the buildings are in a dilapidated state, lifts are not working, and so on. So what one needs there is to get all the people concerned and try and find a way to make sure that when these things are sorted out, too, when they recur in the future, they are dealt with differently than they have been dealt with in the past. But also during this time, one could make a number of contributions in terms of transformation, in terms of how the court works. So I believe that's important. But also, I think there is a good reason, and you probably should agree with me, why, in terms of our constitution, the term of office of members of parliament is five years. The term of office of a president is 5 years. There's a reason for that. You don't want a president who is going to be there for too long. You want to be able to see whether at the end of the first term he is still worthy of being given another chance, and so on and so on. The voters need to see whether they should not change and elect another party as the majority party to handle government. So we had, with regard to the immediate past Chief Justice, we had a Chief Justice who was there for 10 years, and it worked well. And it might work well with anybody in the future who could take a long time. But you don't know. We don't know. So it may, but one of the things that would happen is that if I were appointed as Chief Justice, the position of Deputy Chief Justice would become vacant. And obviously, the President would exercise his prerogative as to who he nominates and so on. But if I'm appointed as Chief Justice, the fact that my term would be 2.5 years might not really be a bad thing. You know, it might well be a good thing, because it may be that at that time, then maybe you could get somebody who could stay much longer. But we have had a Chief Justice who was there for 10 years, and obviously the President will exercise his mind. So I think that 2.5 years has certainly happened. I mean, less than 2.5 years has happened with the Chief Justice. In terms of the study or research that I'm talking about, there are a number of Chief Justices that served 2 years, 3 years, and so on.
Thank you for that. ACJ, you've been part of this panel on a number of occasions, like some of us commissioners, and we have been appointing people who are younger, even to the Constitutional Court, you know, and as judges. Do you perhaps think, in your personal view, that Parliament needs to relook at this 12-year clause, because Parliament can change that in terms of the Constitution? I
know that the former Chief Justice has a very clear view of that, and his view is yes, it should do so. My approach would be that there is nothing wrong in relooking at the matter. The question is what you do after relooking. Do you change or do you leave it? Because when you relook, you reconsider the pros and cons. Now, my starting point would be, let's go back to the beginning. What was the rationale for limiting the term of office of justices of the Constitutional Court? If that rationale no longer holds, then it's fine. I think it can be changed. But if that rationale doesn't hold anymore, if it doesn't hold anymore, changes can be made. But if it still holds, then we shouldn't. But when we look at something like that, we need to accept that those who came before us, they may have had certain wisdom in why certain things should happen in a certain way. So we must think very carefully. So I'm not saying it should not be changed. I'm not saying it should be retained, but I think it would depend on a discussion of the issue, saying what was the rationale initially? Does that rationale not hold anymore? But it is true that we have had situations where justices of the Constitutional Court have retired, so to speak, early when they still have a lot of years that they could contribute. But it may well be that when this body recommends or puts in a list to the President names of judges from which the President must appoint to fill vacancies in the Constitutional Court, it must bear the issue of age in mind and maybe say somebody who might be too young must collect more experience in other courts before going there to the Constitutional Court, because if he goes there too early, he or she will come out too early while they have a lot to contribute. But it is this body that might have to consider. There might be other counter-arguments that must be looked at. But I proceed from the view that says there was a rationale for doing it. We can look at it and ask the question whether it still holds or not.
No, thank you. I think we certainly have our work cut out as members of the legislature in that regard.
Yes.
My last question would relate to some of the other objections that have been filed. Now, there have been many letters supporting your nomination, and you must have gone through them. But there have been those with serious, quote-unquote, serious objections, which I think you must be afforded the opportunity to respond to.
Yes, yes.
Some of those that have written have accused you of a pro-Ramaphosa bias. There are others, and I saw the objection from former Director General Arthur Fraser. That's the second one. And the third one that I listed here was an objection from one Mr. B. Zwane. It's on page, it's objection number 7, I think, or one of them. How would you like to respond to some of these 3 objections in particular? And I know there are other objections which I think other commissioners will deal with. Thank you.
Well, I certainly remember the one from Mr. Fraser well, and I will deal with it. But let me deal with those that you label as accusing me of being pro-Ramaphosa. I don't think that they place any facts to support what they say. It's just their perception as I see it. I'm not pro anybody. I'm not anti anybody. I made the decision as chairperson of the commission way back in 2018, for example, I think second half of the year, that President Ramaphosa would have to appear before the commission because he was part of the executive during the time when these allegations of state capture happened. He was deputy president. He was deputy to President Zuma. He was deputy president of the ANC. And I made an appointment with him as a matter of courtesy to say to him, that is the view that I took. So he must know that I would not consider, I did not think that the commission would have completed its work properly without him coming to the commission and answering questions and giving evidence. And he did not take long when we had that meeting to say he agreed. He said, DCJ, I agree with you. I must come to the commission and account. He did not give me any problems. And of course, he did come. So I made that decision, and I made that decision alone that he would have to come. And he came, and he was asked questions. So, of course, Commissioner Singh, through this commission, I've made a lot of enemies for myself. But it's not as if I did not know that taking this kind of job would land me in that situation. I knew. When the Chief Justice had been asked by President Zuma to find a judge who would chair this commission in accordance with the remedial action of the public protector, he called me as his deputy and told me that there was this task. And we had a discussion. He asked me who I thought we should approach. And I can't remember whether I gave him the name, some of the names immediately, or I said I will reflect and we talk later. But we talked, and I proposed some names. He had some names. And he gave me the task of phoning those judges to try and find somebody who would chair the commission. And the matter was urgent from the point of view of President Zuma. Some of the judges were not available. Others were not comfortable with taking this job. So, as we were phoning and talking to people, when we were in the same room on this particular occasion with the Chief Justice, and I had proposed a certain name of a retired judge, he called that retired judge, and from the conversation I could tell that the retired judge was not available because of other commitments. And he said something which made me think I was going to be the next he was going to ask. So while he was speaking, I had to think what my answer would be. And when he finished, he told me that no, that retired judge was not available. Then he said, "What about you?" I had no hesitation in accepting the responsibility. I said to him, "Chief Justice, if you want me to do it, I will do it." I had realized how it might be difficult to find somebody who would accept this responsibility. I was number 2 in the judiciary. I was the Deputy Chief Justice. There was no way I could run away from responsibility. As I say, I knew that it was going to be difficult. I knew that I would make lots of enemies if I did this job properly, but I accepted that it was a job to be done. And if I made enemies for myself in trying to help the country, so be it. I knew all of this. I can't say that I didn't know. I explained it to my family. I said, lots of things could happen, but we will have to hope that everything goes well. Even now, with all of the things that have happened, if I was asked to undertake a serious task that could mean putting me in a difficult position, if it had to be done, I would do it. So, I'm sorry to give you a long answer, Commissioner Singh.
So you accepted the poison chalice?
I did.
Chair.
But let me...
Sorry for the interruption. Could I ask a follow-up question when the time is right?
Noted, Professor Slim.
Thank you. Then, Commissioner Singh, let me deal with the question, with the objection from Mr. Arthur Fraser. You probably would have seen the response that I gave to the panel when he had raised his objection. Members of this commission will remember that when the State Capture Commission started in 2018, for quite a long time, I would have media briefings where I would invite members of the public who had information about corruption and state capture to come forward. And in particular, I would emphasize current ministers and past ministers and deputy ministers and DGs and former DGs. I would particularly mention those in those media briefings and say, if you have information, please come forward to assist the Commission. Members of this Commission will also be aware that at some stage, I complained that I didn't think that all the DGs and ministers and past ministers who had information had come forward. Because although some had come forward, my view was there must have been many who had information, but for one reason or another were not coming forward. Now, Mr. Arthur Fraser did not come forward in 2018 in response to that call. He did not come forward in 2019 in response to those calls. He did not come forward during the first half of 2020. He came forward after certain witnesses from SSA or former members came forward and gave evidence. And then when he came forward, he said he has information that is very relevant for the commission, and he would give the information, but he needed a lot of documents from the State Security Agency. I think he said that the information he had would, I think his counsel announced at the hearing, would show the involvement of judges in state capture and corruption, as well as, he said, past and present presidents of the country. So we said, no, that's fine. So he applied, he said he was writing to SSA for documents, and at a certain stage, that is now, I think last year, March, he brought an application for an order that I compel SSA and the Minister of Security to make available to him a number of documents. But the State Security Agency came forward and responded to the application and said, we are prepared to give you the documents you want, but we are not sure what documents you are looking for. You must identify them and follow the procedures. You have been DG of SSA, you know what the procedure is. So you must follow it. And he agreed, he accepted that offer. So I didn't have to make any ruling. And subsequently, and this is contained in my ruling in regard to his application for leave to cross-examine certain witnesses, he was supposed to meet with State Security Agency to identify those documents and obtain them, because he said the statement he had given to the Commission is not complete. So it would be complete once he had got that information. But the evidence is that he never went to the State Security Agency to obtain those documents, despite the fact that they invited him to the State Security Agency so that he could see them. He had agreed that he would follow certain regulations that apply in this situation. But they said he didn't comply. He has never explained to the Commission why he didn't follow up, why he did not comply with those. So I looked at his objection now, and I thought this time, because he wrote this objection after I had written my ruling on his application for leave to cross-examine, and I'd raised this issue of why did he not pursue the issue of getting these documents that he said were so crucial for his evidence. I thought that when he objects after that ruling was out, he would explain that, but he doesn't. So it remains a mystery why somebody who said there are these documents that are so crucial, which will help the Commission, didn't pursue them. So the fact of the matter is, one, therefore, all that he had given the Commission was an incomplete statement on his own version, because he needed those documents. He has not said that he can do any other way to complete it without them. But two, he seemed not to want to play according to the rules of the Commission. The Commission has certain rules. If you want to do this, this is what you do. So that is the position. When his legal team was before the Commission, I think in April, I said to them, I'm postponing this application sine die, that is without fixing a date, but I don't want you, when you come back from getting those documents, if you come back and find that we no longer have time as the Commission, I don't want you to say, why did you allow us to get the documents if you were not going to have time? I said to them, when you have got the documents, we will look at what is possible at that time. And he never came back to say, here are the documents, or I'm abandoning the documents, but my statement, I can complete my statement. He didn't. I hope that has covered those that you addressed.
Yeah, there's one about B-Zwane, Acting President. That was the third one.
I don't know if you are able to remind me, I can't remember what it says.
Through you, Acting President. Well, B-Zwane is a generalized objection, but I think one of the things he says that three of the applicants that appeared before us are constitutional delinquents, including yourself. So I don't know if you want to respond in any great detail to that.
Yeah. Well, some of them I had dealt with. I had dealt with when, at the stage of the panel, we provided answers, which I assume have been made available to the Commission. But obviously, if any member of the Commission wants us to go into it, I can look at it and then I can deal with it. But I had provided answers, I think, for all of those, if I'm not mistaken.
Thank you, Acting President.
Thank you, Commissioner Singh. Acting Chief Justice, might I appeal to you? We're approaching 1 o'clock now. Whilst you have the right to answer adequately to all the questions put to you, you should please endeavor to keep your answers succinct. Thank you.
Thank you, Chairperson. I shall endeavor to do so. But of course, these were 3 or 4 questions that came from Commissioner Singh, but I will endeavor to do so.
Thank you very much, Acting Chief Justice. There is a follow-up questions from 3 of the commissioners gathered here. Professor Slema.
Thank you, Acting President. Good afternoon, Acting Chief Justice.
Good afternoon.
The question that was put to you by Commissioner Singh concerning the objection that you are in favor of President Zuma, not President Zuma, President Ramaphosa, links up to a question and a certain uneasiness that I feel to think about you as chairing a commission who has to decide on the credibility of the president and also whether he's guilty of certain actions that are not appropriate. The same precedent that you have to decide upon is the person who may be appointing you if you were to be appointed as the Chief Justice. The other thing that comes into play is the fact that the report is not finished as yet. What can you say to this?
Well, Commissioner Slema, the truth is that in the work of the Commission, the President gave evidence, and like every witness, his evidence will have to be weighed up, assessed. I haven't gone to that, to dealing with most of his evidence, and I will have to make findings. But as I said earlier on, with this job, you have got to do the job, make the findings you make, accept that you may make enemies, but also accept that you may make findings against anybody, including the president. So if there is enough evidence that justifies a finding against the president, that finding will be made. But no finding will be made against the president if there is no evidence that justifies it. just as with regard to former President Zuma, where I've made any finding against him, I've done so because there is evidence. But where there's no evidence, I will not make any finding against President Zuma when there is no evidence. I will not make any finding against anybody when there's no evidence, but I will make a finding against anybody if the evidence justifies it.
So
And if I must suffer any consequences for that, it's fine.
So that should then say that we shouldn't read anything into the fact that that part of the report is not finished yet.
Well, Abba, I don't know what you have in mind, but the report, the idea, as you will recall and everybody would recall, the idea was to complete the report by end of December, the entire report. That was the plan. It was only when it transpired that it was impossible to finish the entire report by end of December that I then decided that let me rather do it in parts. And the reason for that was that I just thought, the country would be up in arms if I said I'm not handing in anything at all by end of December. So I said, at least it's better if there is a part that we hand in. But my plan and the plan of the whole commission, we were working flat out to finish the report, the whole report by December. And I actually, when some of the members of the legal team at some stage tried to say to me, I must start entertaining or thinking about the idea of making an application for an extension beyond December. I didn't want to hear that because I wanted to finish in December. But there came a time when I had to be realistic and accept that I was not going to finish the whole report in December. And then the next thing was, do we then tell the public, the nation, we are not submitting anything until it's everything? But we said, we have done quite some work, so why can't we do it in parts? And we agreed that let's have part 1, part 2, and part 3. So nothing else should be read into it.
Thank you for that, because some people can think that the reason for the report to not be completed is kind of you don't want to blemish the possibility of being appointed as the Chief Justice.
They don't know me if they think like that.
Thank you, Chair.
Thank you.
Thank you, Professor Schlema. Commissioner Magwanishe, a quick follow-up.
Thank you very much, Acting President. Good afternoon, Acting Chief Justice.
Good afternoon to you, Commissioner.
Yes, it's just one question, and I think for the benefit of the public that would not have some of the documents you are referring to, I do understand the part of the cross-examination with respect to former DG Fraser, which is part of the objections. But you have allegations against a person to the tune, I think in the allegation is about 9 billion rands. Didn't you think that it was prudent that he should be summoned to appear?
Well, I can't remember the amount, what the context of the amount you are talking about. But in the commission, there was at some stage a figure that was mentioned by some of the SSA witnesses, which was incorrect. And it was corrected that, no, that's not correct. So you may be talking about that figure that was incorrect. But let me say this. You have somebody who says, I will tell you the whole story. But these statements that I'm giving you are incomplete. The whole story, the other part of the story is in documents. And the documents that he listed were many. I think the list was something like 11 pages, were many. So when you read, when you see that the documents constitute a big part of the story, you know. So the question then is, what's the point of hearing this evidence when it is not complete? And you bear in mind, as I've said, that this person tells you in the third year of the commission that he has this information about state capture and corruption, which involves high people in high office. And he says he knows you have been calling for them people who have information to come forward. But for 2.5 years, he didn't come forward. So you say, do I, at this late stage of the commission, hear this evidence that's incomplete? What would be the purpose of hearing it if it's incomplete? What will I do with it if it's incomplete? And you are actually outside, or you are basically on overtime. Because in March, when he came before the commission applying for an order from me compelling SSA and the Minister of State Security to compel them to give him these documents, we were due to, I think we were due to finish at the end of April or March, I can't remember, but we later applied for an extension. That is why I said to his lawyers when they were before me, I don't want you, when you come back with the documents, to complain if at that time I say we no longer have time, because you will say to me, what was the point of you allowing us to go and collect all of these documents if you are not going to hear us? I said, so go and collect the documents, but when you come back, depending on when you come back, we will look at the situation at that stage, because we are already on extra time. And as it happens, he never came back. The next time I heard from him, I think the commission sent him, or his lawyers, a notice to say, please make written representations about A, B, and C, which he did. And then the next thing was when he lodged an objection. But he has never had the courtesy of coming back to the commission and say, Chairperson, you remember in March I came to you, I wanted you to force SSA to give me documents, and you allowed me to go and get them. This is what happened. He has never done that.
Thank you, Acting President.
Thank you, Commissioner Magwanisha. Yet another follow-up from Commissioner Mapisa Ngagula.
Thank you very much, Acting President. Good morning.
Good afternoon, Madam Speaker.
Good afternoon, Acting President Zondo.
Sorry?
Acting Chief Justice Zondo. No, my follow-up question to you is on the very matter which has been raised by both Honorable Singh, Commissioner Singh and Commissioner Magwanisha. The issue for me is, I've read the entire objection by Arthur Fraser. And I'm fully aware that there are documents which he requested from State Security, which finally he himself did not make himself available to get those documents. Now, between what happened to SSA and State Security and Arthur Fraser, that's another matter. The question I have is, the allegations against Fraser were damning allegations. Whether it's equal to 9 billion or 1 billion or 500,000, but the point is they were damning allegations. And I know for sure that there are many people who were summoned or subpoenaed to appear before the commission to present their side of the story on whatever had been presented about them. The question is, didn't the commission see it fit that with all the toing and froing between Arthur Fraser and state security, and Arthur having approached you and said he would want to appear, and you and him wanting more information. Now, at that point, would it not have been incumbent upon you to say, look, we've given you time, you were here in March, we're moving towards the end of everything. We're wrapping up the commission. And the allegations which have been presented here to this commission against you are damning allegations. And therefore, we are now summoning you to appear before the commission to answer for yourself or to explain or to whatever it is, but for you to be able to raise all of the issues you would have wanted to raise directly with him. Not that the commission was a court of law. Obviously, certain things are going to happen beyond this. But with everything which had been raised about state security in particular, honestly, don't you think it would have been proper to say the accounting officer at that point, whose allegations against him were really weighing very heavy on everybody, should appear before the commission, should answer for himself or present his side of the story to the commission? Thank you.
Thank you, Madam Speaker. Let me put it this way. The rules of the Commission say if somebody has given the Commission an affidavit or statement which implicates somebody else, the Commission must issue what we call Rule 33 notices. The Rule 33 notice tells you, the person who is implicated in that witness's statement, that there is this person who has given the Commission a statement that implicates you, and here is that statement that implicates you, or here are portions of that statement that implicate you. And then it says, the notice says to you, if you want to challenge this evidence, you must apply to the Commission for leave to give evidence or to cross-examine the person. And when you apply, this is what you do, okay? Now, what that does do is that it gives you, the implicated person, an election. You can decide that you don't think that this witness implicates you, or his or her statement implicates you, and therefore you do nothing. Or you can decide that even if it implicates you, you don't want to challenge it, you don't care, and then you do nothing. Or you can decide that you just want to give the Commission an affidavit that sets out your side of the story without you wanting to give evidence orally or to cross-examine that person. You have an election, you can do any of those things, okay? Now, some of the there are many people, thousands if I recall correctly, maybe over 3,000 people who were served with 3-3 notices by the Commission. Of course, we did not hear 1,000 witnesses. So there are many who decided that they did not want to challenge what those witnesses were saying about them, and they did not want to cross-examine them. They just left things like that. Now, some of those, okay, let me first say, if you decided not to do what the rules say you must do if you want to challenge what has been said about you, if you decide not to do that, you can't complain afterwards and say, I was denied the opportunity of putting my side of the story, because the rule, the notice that the Commission sent to you told you that if you want to challenge this evidence by this witness, this is what you must do, and you decided not to do anything. So you can't complain that you were not given that chance. Then in that event, but the fact that you have chosen not to do anything did not deprive us as the Commission of the power to compel you if we think we should compel you. Okay? That is why there are people that the Commission compelled to come before it and answer certain questions. But part of the problem with Mr. Fraser was that he seemed not to want to comply with the rules or processes of the Commission. If he wanted to testify, all he needed to do is to apply, and his application would have been decided as many other people had applied and they were decided. He says, I didn't want him to testify because his evidence would disturb the narrative that I wanted to follow. But the best way for him to test that would have been for him to apply for leave to give evidence and see whether I was going to refuse. Because if he applied and complied with the rules of the Commission, the matter would come before me in open court and in an open hearing, and then I would have to make the decision. He decided not to do that, but to want to be treated outside of the rules. But more than anything, the problem with Mr. Fraser was the time when that kind of decision could be made. I could not make that decision in March, because in March he still wanted to get documents from SSA. So, and he never came back to me to say, I didn't find the documents, or I don't want to use them anymore. So by the time when he complains that I didn't call him, when we look at that time, we've got to look at the last part of 2021, when the oral evidence had been completed in June. So if I were to have decided to call him after I got to know that this route of getting documents from SSA was not being pursued, it would have meant that I would have had to reopen the hearing of evidence maybe in October, and then another complication with him was that he could implicate a lot of people who had previously not been implicated, which would then mean we must give those people opportunities, and we were running out of time. But if he had approached us in 2018, when I made that call to say, all DGs, past and present, and ministers and deputy ministers who have got information that is relevant to the Commission must come forward. There would have been enough time to deal with all of this. Thank you.
Thank you, Acting Secretary.
Thank you, Madam Speaker.
Thank you, Commissioner Mapisa Magula. Commissioner Malema.
Thank you, Acting President and Deputy Chief Justice.
Thank you, Commissioner Malema.
I think that we hear each other very well, and the answer you are giving, which is so long, is deliberately trying not to answer the question on Fraser. The question on Fraser is not what he has done or he has not done. The question on Fraser is, it's an accounting officer of an institution that got highly implicated, and figures and amounts of money were thrown around, whether this or that amount of money. It is immaterial. Why didn't the Commission compel him to come and answer as a former accounting officer? Not what he wanted to do on helping the Commission. No, that is his part, which he has not done. We have no problem with that. Fraser and the institution he was leading gets implicated in the Commission. Amounts of money gets thrown around. Zizi Gotwa gets called for 1 million rand. Here is a person who was leading a strategic institution of the state, and that institution is implicated. Zizi Gotwa did not lead any strategic institution of a state. Didn't work for government. He worked for the ANC. He gets called, come here, your name is here, you were told you got 1 million, come and tell us. Yeah, Fraser gets implicated, monies are thrown around from the state coffers, and he's not called and compelled to come and answer on those allegations made against both him and the institution that he has led. Why?
Well, Commissioner Malema, the question has been answered. Let me repeat. In March, Mr. Fraser said, I need documents from the SSA to give you a full picture. I want to give you a full picture. Okay? So at that stage, there was no reason to think that he would not pursue that route of getting all those documents that he said were so important for him to, because he said it's for him, they will help him to respond, among other things, to the allegations against him. Okay. Then he goes away with my permission to say, okay, this application that you brought, that I should compel the state security to give you these documents, we postpone it without fixing a date. And I even said, if you don't come right, you can come back. I was talking to his lawyers, obviously not to him. If you don't come right, you can then come back to me and revive this application, and we can take things from there. But I said, I do want you to know that we are running out of time. When you do come back, we will assess the situation at that time. He never came back. And if I were to decide whether to compel him, I would have to have made that decision maybe in October, maybe in September. And that was too late. But I had warned him or his lawyers that when you have received the documents and you come back, you must know that we will assess the situation at that time to see what is possible and what is not possible. So we didn't call him, partly because his story was not complete, because he had said he needed the documents. He had said to us he needed those documents, he would go and get them, and we expected him to come back. He never came back. actually in June, and I think my ruling indicates it was 17 June, if I'm not mistaken, the Secretary of the Commission wrote to both to his lawyers and to the lawyers of SSA and said, effectively, what is happening about the documents? And his lawyers did not respond. The state attorney representing SSA is the one that responded and told and said what was happening. So if any decision had to be made, it would have had to be made maybe in September or thereabout, which was quite late.
DCJ, there are two types of people the Commission deals with. There are people who got called upon, former ministers, DGs and ministers and all, who must come forward to help the Commission if they can and bring whatever information they want to bring. And Fraser came late with regard to that. And even when he came, he said, there's these documents I need to help the Commission. I understand that. Then there are these ones who get implicated in the Commission, where the Commission realizes, no, this one will have to come and answer this, not these things that he wants to give us. These ones we can hear you. We want you to come and answer on these ones. And there he doesn't take an initiative. The Commission takes the initiative. Did you do that with other Fraser when he got implicated and write to him and say, come here, the following things are implicating you, we want you to come and answer?
Give me a moment, Acting Chief Justice.
Oh,
Commissioner Malema, could you please try and moderate the tone of your voice? Thank you.
No, I don't understand that. I speak like this. I must moderate what? I speak like this. This is how I speak.
Now, Commissioner Malema, you are shouting now, not speaking.
No, but Chair, I speak like this. I can bring all types of videos you want to see of me speaking. I speak like this. I'm not fighting. He chairs these meetings all the time. He knows I speak like this. I'm not fighting.
For the sake of progress, shall we please give the Acting Chief Justice to respond to your
Please.
question?
thank you, Chairperson. You see, Commissioner Malema, there are people who were implicated, and there are many of them, whom we did not call, even though they were implicated. On their side, they decided they were not going to do anything, even though they were notified that they were implicated. And we ourselves decided not to call. Okay? There are many of such people. But there are some that we decided, but we must call this one. And that depended on a number of things. One of which would be when we still had a lot of time, we could call a lot of people. So what I'm saying is, first, after you have served the notice, Rule 33 notice on an implicated person, you wait for them to see whether they are going to make an election to apply for leave to testify, or for leave to cross-examine witnesses, or for both. After some time, if they have not done that, you have to make a decision whether you must call them nevertheless, even though they didn't say anything. And some we called, others we didn't call. But with regard to Mr. Fraser, what I'm saying is, before March, there was no reason to force him to come to the Commission, because in June or July 2020, he had come to the Commission with his legal team and said he wants to give evidence, he has a lot of evidence, but he wants certain documents from SSA. So he was going to come back, and we had no issues with that. But until March, we didn't know what was happening, but we were clear that he and his counsel were very emphatic that they would come back. He wanted to testify, but he wanted certain documents. And then in March, he applies to me to say, compel SSA and the Minister of State Security to give me these documents that are so important for me to respond to these allegations and to tell you about state capture and corruption in general, I think. So I say, okay, but we are on extra time. When you get them, we will see what can be done. And he never comes back. By the time I could have made any decision to say, okay, he's no longer come back, it would have been about September. It would have been too late. And my view would have been, it's so late, his evidence might not just, well, first of all, he said those documents would help him also to respond to these allegations by these witnesses. So he would probably implicate other people, and then who would want to come, and the commission was required to complete its work. So that was the situation we were faced with.
Chair, but my problem here is that he says he's implicated in a 9 billion, and you say there's a different figure. Surely, the commission that is investigating corruption can't miss to compel a person implicated in a 9 billion scandal from state security where there is slush fund and some of which is not even accounted for. This would have been an opportune moment for the commission to expose the rot that has constituted some of the activities in that institution. So I hear that, but my problem is that you still don't call him on your own to come and account for 9 billion, because I'm telling you 9 billion, that's what he says. He says in his objection, I'm implicated on 9 billion. And I'm shocked I'm not compelled to come and answer on this 9 billion.
Well, you see, Commissioner Malema, one of the things we had to accept, certainly I had to accept as chairperson of the commission as we went along. I mean, there were many issues that I would have liked the commission to pursue. But I had to accept that I am not the only one. Anything that I've not investigated, it doesn't mean there's nobody else who can investigate. I must accept that there are other people who can do the job and other agencies. There was pressure that the commission must finish its work, and you might have seen when I applied for extensions how there would be complaints about this commission is not finishing its work, and there were challenges about money. So we needed to make a decision, and certainly I would have said, look, one, we have evidence that implicates him in a certain way. He has been given an opportunity, if he wants to challenge that evidence, to comply with the rules and apply, and then that application would have been decided. He chose not to do that. So he must have had a reason why he didn't want to do that. And he certainly had lawyers, and the lawyers he had knew the procedures of the commission. So he might not ultimately account to the commission, but the evidence that has been led before the commission will be available to law enforcement agencies and to other people. He might end up accounting anyway. So I mustn't prolong this commission as if I'm the only one who can investigate everything.
On a separate matter, the courtesy to President Ramaphosa to come and account, let me understand, how did that come about? And in terms of the rules of the commission, which rule is that? Is that one?
Well, it wasn't in terms of any rule of the commission. Remember that this commission, the commission is a presidential commission. It was established by President Zuma, but once he left office, basically it gets inherited by whoever the president is. So it's a presidential commission. One of my obligations is to update the president as to how the commission is doing, which I was doing. So I would meet with him from time to time. I would meet with him when there were, for example, challenges about budgets. There was a time, some of the commissioners may recall, when it was in the media that investigators and the legal team had not been paid for a long time. There was a time when Treasury was not giving us money and Department of Justice was not giving us money. And it had gone on for a long time. I realized that if something had to be done, I needed to speak to the president, because the next thing, the legal team and the investigators would leave. You know, it would be unreasonable to expect them to continue working without being paid for I think at some stage they had not been paid for 3 months. So I had an obligation to meet with him regularly and appraise him about what is happening and what challenges there are, where I think he should come in, because it's a presidential commission. But then I also said, you will have to come and testify before the commission finishes its work, and he agreed.
According to which rule do you have to brief the president from time to time about the work of the commission? Because if the president has established a commission, that's it, because it might be seen as if you are now compromising the independence of the commission by constantly briefing the president, whereas if the president is also an implicated person in the commission's work.
Well, the rules of the commission talk about the proceedings of the commission. They don't provide for everything. They don't deal with everything. You know, they basically provide processes how certain things are done, how witnesses come to the commission. So they don't deal with that. But my understanding is that judges who have headed other commissions would do that. They keep if it's a presidential commission, you keep the president informed of the progress of the commission. If it's a commission established by a premier, you keep them informed how everything is happening, is going, and if there are any challenges, you update him.
How would you respond?
Commissioner Malema, excuse
The last
me.
one, last follow-up on a separate matter.
Okay,
Yes.
very last one. Thank you.
The release of the last report, which is likely to implicate the president, is that not a sword on the neck of the president that he must appoint you, or if he doesn't appoint you, the report is likely to go a different way? Because there are two parts of the reports which were released. Why was the president's side not included in the reports which were released before this interview? Because we're human beings and we're politicians and we're political animals. If you have a report on me and you don't release it, and I've got certain obligations towards you, I might be tempted to do the right by you, otherwise I'll be dealt with wrongly. So how will you respond to this, that this serves as a sword on the neck of the president, because if he doesn't do the right thing, the report is likely to go differently? Thank you, Chair.
Well, interestingly, I never thought about that angle, Commissioner Malema. But I think the reason why I never thought about it is it's because of how it came about that we decided that the report would be in 3 parts. And how it came about was that for a number of months before the end of last year, we were working flat out to complete the whole report by end of December, because the order of the court that had granted us an extension had given us up to the 31st of December. That's number one. Number two, I wanted to finish the work of this commission. I mean, for 4 years, I've been doing this, the work of this commission. I haven't had much time to rest. I haven't had much time for my family over the 4 years. There are times when I've worked right around the clock without sleeping to try and push the work of the commission. If there's one thing I would like behind me is to finish the work of the commission. So towards the end of last year, I was pushing everybody, saying we must finish. So when I realized that we were not going to be able to finish the whole report, we looked at what portions of the report would be ready by end of December to release. And those happened to be the ones that were in part one. And the ones that are in part two were those that were closer to being ready. So there was no conscious decision to say, oh no, that part must come later because of what. It was simply which parts were closer to being ready by a certain time in December, and saying there is no way we can face the nation and say we want an extension but we are not submitting anything. Let us submit something at least. That was the idea. Thank you, Commissioner.
Thank you, Chair. Thank you, DC.
Follow
Thank
up.
you,
Follow up, Acting President.
Commissioner Mlambo. Commissioner Nyambi, please bear with me, Minister. I had Commissioner Nyambi long before you.
Oh, okay.
Thank you.
Thank you, Acting President. Afternoon, DCJ.
Good afternoon, Commissioner.
It's one follow-up from my part, taking it from the question of Honorable Singh. I don't want to misinterpret what you are telling us so that when we are having deliberations, it's used against you. You said you knew when you were identified to lead the commission that will create enemies. So I asked myself a question that how is that possible? Because you had a clear and objective mind. It was possible to get it there and only to find that there was no corruption. So I want to have that understanding that how can you create enemies before you can get the actual commission starting its work and get the road that was happening in the country.
Yes. No, I think what I mean was you can't run a commission like this without a situation where at some stage or another you are going to make rulings against some people. You might have to make rulings against people in relation to actual corruption. But obviously at that stage, I didn't have the evidence. But I know, as much as all of us know, that South Africa has had a high level of corruption for a long time. Leave out state capture, just corruption. And remember that the commission wasn't looking, in terms of its reference, was not just going to look at state capture, it was going to look at corruption as well. And therefore, it's highly unlikely that you would have this commission in a country that is so full of corruption, and you would think that you would not find any evidence and make findings of corruption against some or other people.
Thank you, DCJ. Thank you, Acting President.
Thank you, Commissioner Nyambi. Honorable Minister.
I just want to check, Acting Chief Justice. You applied several times to court for the extension.
Yes, I did. And I must tell you, Minister, that each time I didn't like this idea of applying for an extension. Actually, initially in 2018, I thought it was the President who should apply because it's his commission. But he got a legal opinion that said I must apply, so I had to apply. So I've been the one applying all the time and the one taking flack.
Yeah, so obviously most of the time when you had to apply for the extension, you will have to talk to the president or sometimes to the minister because there will be implications on the work of the commission.
Yes. Certainly, my approach was that this being a presidential commission, the president should not hear it from the media that we were applying for an extension. And obviously, the minister and the department were supporting the commission, and they also needed to hear. But most of the time, I dealt with the president.
Yeah, and sometimes there could be budgetary issues that, for example, the department will have to consider and advise the president, vice versa, and the commission.
Yes.
Including you talking to the president about these budgetary challenges that
Yes.
the commission is dealing with.
Yes.
No, thank you.
Thank you.
Thank you, Minister Lamula. Would the members of the commission allow me to take Mr. Nokesi before the lunch adjournment? Thank you. Commissioner Nokesi.
Thank you, President. Good afternoon, Acting Chief Justice.
Good afternoon, Commissioner Nokesi.
Firstly, I must record that the four of you as the candidates, you are role models to me.
Thank you.
And we have done a lot for this country.
Thank you.
It's worth for you writing more than 200 judgments. That is prolific writing with articles and publications.
Thank you.
So whatever questions I ask either from you or other candidates
Yes.
are genuine, there
Yes.
is nothing,
Yes.
obviously, we just want to clarify issues.
Thank you. Thank you.
Yeah. Now, from your presentation, what I must appreciate again, you gave a detailed insight to the Constitutional Court, the workings of that court, the challenges, and therefore I have a better understanding of that court, and I must commend you for that. I definitely have no much questions to ask you in relation to that.
Okay.
We have to discuss in relation to your capacity as the head of the judiciary. And even there, I must break it down to the leadership. I think that's where we'll focus. And to begin with, my question is, would you consider your appointment to the commission as the chairperson as part of your leadership enhancement, as part of your leadership, which must be considered in the context of you becoming the Chief Justice?
I'm sorry, I keep on forgetting that I don't have to press here. Thank you for that question, Commissioner Nokesi. Yes, I consider that when you, honorable members of this commission, consider my candidacy, you should consider the question of my chairing of the commission.
Yes.
I say so knowing that some criticize me about how I chaired it, others like how I did it, but I think either way it's fair.
Yes.
And so yes, I think it should be considered.
Yes.
Thank you.
Now, the first question I want to, is from my experience. In the Eastern Cape some time ago, a commission was established. It was headed by the late Justice White. That commission, after it was concluded, litigation arising from it lasted for more than 10 years. There were many cases. The chairperson here may attest that at some stage, I think he was one of those involved in matters arising from that commission. So do you agree that any commission is likely to end up in court with reviews, all those involved being called upon to give evidence, testify. Do you accept that?
Here is what I accept, Commissioner Njesi. I accept that after the commission has completed its work and submitted its report, there may be a number of people who launch review applications. Those review applications are normally decided by the courts on affidavits without the need for oral evidence. So that I accept will happen. But I also need to say that the commission or commissioner would decide whether he or she wants to oppose a particular application or not. He or she might decide, I will abide. Let the court decide. So he or she might not be so involved in those cases after the commission has finished its work, because he or she takes the attitude that my report speaks for itself and I'm not going to be involved. So, but sometimes, commissioner might decide to oppose. It could happen,
Now, the commission, that is the State Capture Commission report, like all the other commission reports, because people have been implicated, everything has been made, it will be challenged in court. I mean, that's a realistic chance.
I agree. And I would not be surprised if, before I even filed the first part of the report, I would not be surprised if some people had prepared papers, they are ready. They're just waiting to get the report, complete the papers, and lodge. They will be.
Now, obviously, if that is so, whether you will decide to abide, whether you will decide to oppose, you will be involved in litigation as the chairperson of that commission in the next 6 months, 2 years. In fact, as I indicated, based on my experience, the next period from here is you being involved in court litigation in your capacity as the chairperson of the commission. Whether you say, I don't oppose, or you oppose, but definitely that is going to happen.
Well, let me say this, Commissioner Njesi. If, for example, I'm not opposing and I'm abiding, that means my name is there, but otherwise it's not taking my time, because I'm not filing any affidavit, I'm not opposing. So, and you will have seen, I hope, from part 1 and part 2 of the reports, that we are giving detailed, we analyze evidence quite extensively before we make findings. And therefore, it would be easy for me, for example, to say, look, we have analyzed evidence, the reasons for the findings are there, let the judge decide. So I don't know what decision I will take, but I'm simply saying there are different scenarios. If I'm not opposing, those applications would not involve my time.
No, so that I pass on from this point. The point I want to make to you, Acting Chief Justice, is that in appointing you as the Chief Justice, this commission, yourself, and all of us must understand that we will be appointing a Chief Justice who is likely to spend a greater part of his time either opposing court cases or risking of the report, of which more than 2 billion has been spent, being set aside because it's not opposed.
You must be careful, Commissioner Njesi, not to send the message to other judges that if in the future there is a need for a judge to chair a commission, they say, hey, I don't want to agree to chair this commission because After the commission, there will be there will be reviews, and I might not be, that might affect my career adversely, because now it will be said I will be involved in all of those things. We want to encourage judges, when they are called upon to perform this kind of function, to consider it favorably, because it's an important duty for country. So one, I don't think it's the kind of thing that really should be a problem. And one, I might not oppose, partly because we give detailed reasons why we have come to certain findings. Two, it might be that we say, well, let the court decide. And maybe there will be other people who will oppose. Yeah, thank you.
Look, I mean, you get my point. It is undesirable in any country to appoint a sitting judge, especially the head of the court, such as the Chief Justice or Deputy, to chair a commission of inquiry. And that I will demonstrate to you by what now has followed up. I've read no less than 8 objections against you. 2, there is this possibility which we both of us agree of the matter taken to court, remaining there over some years, because go to the High Court, appeals, it's the next 5 years, and your period left as a Chief Justice is 2.5 years. This is a risk that, to me, from day one, ought to have been avoided. And you do say, so that I want you to answer holistically, you do say some judges were phoned, were called. But why did you not simply appoint a retired judge to deal with this? Take all the evidence, because you won't have the complaints such as those of Fraser. They would not have much time, complaints and all those things. Just on reflection, as a leader, I'm asking you this question on the basis of your leadership in relation to this decision, to me, which was critical and it affects us now.
Well, one, you will recall that I said we called a number of judges, and I can't remember whether it was one retired judge or it was more that we called. But when I realized that the Chief Justice could turn to me, he was speaking to a retired judge, because we were trying to get a retired judge. President Zuma had said to him, this matter is urgent. Chief Justice needed to go back to President Zuma without delay. So after our efforts had failed with a number of judges, he turned on me. And I took the view that as part of the, I would have preferred to continue in court as Deputy Chief Justice. I had not finished a year having been appointed as Deputy Chief Justice. I enjoyed the court work and so on. But I took the view that the country needs somebody to do this job. The Chief Justice of the country has tried to get other judges, but now he has turned to me. I can't say no. So that was my approach.
And there is this complaint of, which is worrying me, complaint of this Thabo Mtsweni, which relate to the recusal application brought by Mr. Zuma, where I will just read. Acting Chief Justice Zondo became a witness and was also a judge for the same recusal application against him by former president. He gave his version of events against those raised by former President Zuma, and later gave an order against former President Zuma. That's how he summarizes. Yeah. I don't want to get into the business of this. But what I remember, I don't get it. If it's not so, correct me. There was an application launched pursuant to this for review.
There was a?
Was there any application for review launched pursuant to that recusal?
Right. Yes, there is a current pending review application against my decision not to recuse myself.
Yeah.
Yes.
Now, you are the Chief Justice there. That case will go up to the Constitutional Court. And they will go all the, even if it's on another court, from somebody outside there sitting objectively. Here is the Chief Justice who is accused in the manner that it is set out here. And they will have to make a decision because they say you gave you evidence, whether right or wrong, that's what they say. The court has to decide now about which version to believe, yours and that one of the... Look, is it not a very awkward situation? In the form of a Chief Justice, that is a point, emphasis that I want to make.
Let me just understand, is the question directed at simply that I refuse to recuse myself in circumstances where maybe other people might think I should have?
No.
Or is it that I have a certain version which is different from that of President Zuma?
No, let me simplify. It's all about the desirability of a Chief Justice or the leader of the court being involved in litigation and the implication to the colleagues vis-a-vis the public perception. That's the question.
Well, let me say, you know, we have a very independent judiciary. You will recall, if you did get a chance to read the first judgment of the Constitutional Court, in where the Commission asked the Constitutional Court to issue an order compelling President Zuma to appear before the Commission. You will recall that my colleagues in that judgment did criticize me. They said I had been too, as I recall, I'm putting it in my own words, I'd been too soft on President Zuma. So I have a situation where my own colleagues said I was too soft on him, and other people say I've been harsh on him. So the point I'm making is that, one, my colleagues would not be deterred from making whatever conclusion they need to make just because I'm one of them. And you have seen in the Judicial Conduct Committee, judges have made decisions against other judges. There was a judgment against Judge President Lope, there was a judgment against Chief Justice. So judges seek to do their job the way it should be done, irrespective of which judge, what is their position in the judiciary. They try to do that.
Yeah. The other criticism, going past on this one, the other criticism, during the proceedings, in what ultimately resulted in some complaint in the scuffle between Mr. Mpofu and some other, you hold a conference about the proceedings of a commission. Instead of making a ruling there, the matter ends. But you have to hold conference. Is it something normal that if a DC is being chaired, a DC, an inquiry, a court hearing, one of the lawyers misbehave or one of the parties, that a judge must go and actually call a press conference about what is going to, is it something normal?
Well, you see, Commissioner Njesi, different people would have handled this commission differently.
Yes.
Okay?
Yes, I agree.
Maybe somebody else would have handled the matter differently.
Yeah.
This is a commission that has a lot of public interest, and what happened publicly. Yeah. And I don't think that I should have dealt with the issue privately when it had happened publicly. I thought I should deal with it transparently. That's what I did.
No, my point is not, the commission was public.
Sorry?
The commission was public. We could watch all of us. The issue here, my take, is the press conference.
Yeah. Because
you called for a press conference. About your ruling and your decision. Is it a normal thing by judges or chairpersons?
Actually, now I remember. I don't think I called a press conference.
Okay.
I simply made remarks or made a statement from the commission hearing where the event had happened. I think after 2 days, after I'd reflected on it, I didn't call a conference, a press conference, but the proceedings were broadcast, yeah. But I didn't particularly call.
No, I'm sorry
Yeah.
to say you called for it.
Thank you.
Now, the last aspect. With all these complaints, like we turn to you now as the chairperson of the JSC,
Yeah.
because that's your role as the Chief Justice as well. Out of these objections, I'm right or wrong, I did not look onto the demerits and merits. Do you know if there are complaints that have been filed against you? Is there anyone who has filed a complaint? Or is there any complaint against you arising from all that work?
Well, there is no complaint that I'm aware of that is currently pending against me. There were complaints at some stage before which were dealt with. As far as I recall, as far as I know, there is no current complaint pending. Yeah.
The complaints that were filed arising from the commission were filed but they have been dealt with.
There was, as far as I know, only one that arose from the commission. It was filed by Mr. Montana. It was dealt with and it was dismissed. He didn't take it further.
And you were the acting chairperson of the sub of the JCC at the time, but you just have to recuse some of them.
Yes, I did not
which
take
is
part.
normal.
Yes, I did not take part, yeah.
And if there are others that will come arising from all these things, an awkward situation is that it will affect your participation there because they will be coming, we don't know. Because I'm looking on the number of objections, if there are anything to go by.
Well, firstly, those people have made objections here, but have not lodged complaints with the Judicial Conduct Committee. I don't know whether one of them may have lodged a complaint before and it was dismissed. I can't remember. But as things stand, I'm not aware of any complaint that they have lodged in the JCC. Yeah.
Last question is simply on the model that you discussed with the minister of the OCJs, of the OCJ, as the department.
Yeah.
It's a pity that you present, and I listened to Judge Mlambo even yesterday, you presented the document which has been agreed by the judiciary. This is what they want. Can't you consider the implications on the independence of the judiciary? Because once you have this department, I know you want to come with councils. You say there must be councils. Bypassing what actually should happen. Because when you have a department, that department must go to Parliament. Because Parliament must vote for your budget. You must have an administration. Is it not going to bring tensions between the executive and the judiciary? That's one. Two, the public appearance, public perception. When judges spend a lot of time sitting, as it is happening now, I listened to Commissioner Malema and the minister having to explain that judges spend time with the executive because you have to, once you run there, you take full administration because that's what the department entails. Is it not going to impugn or to trample upon the issue of the independence of the judiciary, institutional independence? The one that you think you seek, are you not actually compromising it?
No, not at all, not at all. Actually, other countries have, some countries have achieved that level of independence. The fact of the matter is, even under that system, it is accepted that there would have to be somebody who goes to Parliament. For example, phase 2 of that proposal says that the office of the Chief Justice should be established as an entity that is similar to the Auditor General. And the office of the Auditor General goes straight to Parliament. You see, it does not like having being attached to a ministry, you know. So what basically is that phase 2 contemplates is that before you get to complete institutional independence, you are going to have that situation. But basically, it doesn't mean there will be no accountability, but it simply means everything is within the judiciary.
You agree with this? Would you agree with the statement on the individual independence, personal independence of judges? Would you agree with the statement that the greatest threat to the independence of the judges or of the judiciary is the judiciary itself? Why so? If you endlessly reserve judgments, if you conduct in a manner that people must question, must have question marks, if you enter into phrase or spaces that judges are not ordinarily allowed to enter into, and many other, but the biggest threat to the judiciary is the judiciary itself on how it must conduct or it conduct itself.
Well, I would not agree that certainly within the context of the South African judiciary that the biggest threat to their independence is themselves. But what I would agree to is that the judiciary must be careful not to do things that would actually impact negatively on their independence. The way we behave ourselves, we conduct ourselves, we need to make sure that we conduct ourselves in an appropriate manner. So in other words, yes, there are things that we as the judiciary can do that could impact negatively on our independence, but I wouldn't go so far as saying that we are the biggest threat to ourselves.
No, I would make as I've said. If you reserve judgment endlessly, people are allowed, they are free to criticize you. They can even go to a rally and say, our judgment is kept by that judge. They can do that. Two, if you behave in a particular way. For instance, I know this is a call, maybe it might be sensitive, otherwise I must ask, I would not be correct. When you call for the press statement in reaction to Minister Sisulu's criticism, would it not have been simply sufficient if you, as the judiciary, you just write a strong worded statement through the office of the CJ, rather than calling for a press conference, allowing journalists to ask questions, ending up having questions that you don't have to, you are unable to answer at that level. Because the next thing is for Minister Sisulu to call her own conference, and the whole thing, the whole week is occupying the space for a month, debating, that drags the judiciary into the public space. Like on a further reflection, I'm not criticizing, it was your call, but calling the press conference itself, was it an appropriate action?
Well, one, I think it was, but let me tell you how it came about. Initially, I thought one would issue a statement. I think about 5 or 6 days had lapsed since that article had come up, had been published, or at least had become known. I may have known it after 2 days or 3 days about it. Initially, I was thinking I should issue a media statement. This happened in the course of a very busy schedule on my part when I was preparing part 2 of the report, working extremely hard. So at a certain stage, I think I had wanted to issue the statement before lunch, but at a certain stage, I realized that I had not been able to get the statement ready. And it occurred to me that it might only be ready the following day. So, but I was clear in my mind what I wanted to say. So I decided, look, there's already been so many days, so let me just go public and do this. But I took the view that I want to try and limit myself to that which I consider to be an insult. I don't want to get involved in other points.
Thank you, Acting President. But once more, Acting Chief Justice, I must say we are inspired by your work.
Thank you
as a
very
judge, especially that only you and Judge Mlambo are the only attorneys in this list of 4.
Yeah.
And also as an attorney, you have gone progress to the stage where you are as the Deputy Chief
Thank
Justice.
you very much. Thank you very much.
Thank you very much.
Thank you.
Members of the Commission, I'm sorry to disappoint you. I'm informed that our dining area is crowded at the moment, so we would be well advised to continue for another 15 minutes. So if you would kindly bear with me. Thank you.
Is it possible to get a convenience break?
A comfort break at this stage, Acting Chief Justice.
Well, I was just saying a convenience break, a brief one. I think Commissioner Malema understands what.
No, the chair must understand you better than me.
Maybe I thought if you tell him.
I hear you. He must hear you. I hear what you are saying.
Yes, please.
Well, there is a
Yes.
witness.
Shall we then take just a 5 minutes adjournment?
Chair, I will propose we go to lunch. There's nothing crowded. We're all here. We are South Africans. So let's just go to lunch.
I suppose so.
Yeah.
Let's reconvene then at 3 o'clock. Thank you.
Thank you.
If the chairperson does not hear you, Acting Chief Justice, you will have run away from this.
No. I think I know. I must just contact Commissioner Malema. He will make sure he understands me.